Good morning, everybody. Happy Wednesday. Welcome to TCF Live. My name is Dan. I'll be with you for the next 3 hours of this journey through Courtlandia. We will get it started with Judge McNally. Come on.
Does I understand?
We'll get it started with Judge McNally just as soon as I learn to do two things: speak and press buttons properly. Let's try again. Good morning.
He did make on the 2 p.m. blows. He's telling me he thinks he just fell asleep and missed those. On the 2 a.m. blows, he was at work. He provided a 4 o'clock specimen. He provided a noon specimen, and from his memory, he thinks he might have blew late on one of them, but that's his recollection.
All right. We talked about this at sobriety court this morning a little bit. The probation officer was here, and my understanding was it was just not submitting the timely blows. I'm going to go ahead and take the plea as though that was the case. If you plead guilty here, this would be 4 technical violations. You could have your probation revoked, and you could be incarcerated for up to 93 days. Do you understand that?
Yep. Yes.
All right. And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
Okay. Your name, please.
Madeline Marcus, probation.
First one today for her, right?
First one, yeah, first one.
All right. So my understanding is he just submitted, he didn't blow into these timely, right?
Correct. So the first 2 counts 1 and 2 that are listed, he did blow late. So they were, I believe, 40 minutes late and 48 minutes late. Counts 3 and 4, he did not make up those blows.
All right. So do you understand all the charges here?
Yes, sir.
All right. So I'm going to ask you, can you understand if you plead guilty, you're giving up all of these rights on the advice of rights, true?
Yes, sir.
All right. Mr. Sparrow, I do have a new appearance from you, do I not?
I will get you one. I did not follow it.
Okay, I'm gonna need you to do that here.
Yeah.
Would you hand him one, Sadie? All right, to the charge that you failed to blow into your Soberlink on March the 19th at 8 p.m., how do you plead?
Guilty.
Did you fail to blow into your Soberlink on March 19th at 8 p.m.?
Yes.
Count 2 that you failed to blow into your Soberlink on March the 21st at 8 p.m., how do you plead?
Guilty.
Did you fail to do that?
Yes.
Count 3 that you failed to blow in your Soberlink on March 23rd at 8 a.m. How do you plead?
Guilty.
Count 4 that you failed to blow in your Soberlink at 8 a.m. on March the 24th. How do you plead?
Guilty.
All right. And did you fail to blow in your Soberlink at 8 a.m. on March the 23rd as well as 8 a.m. on March the 24th?
No.
I'm asking, did you fail to do that?
Yes.
All right. And then you did not blow into the Soberlink on the 19th at 8 or the 21st at 8 p.m., correct?
Correct.
All right. Anybody force you to plead guilty?
No, sir.
Plea is accepted to those 4 counts. Okay. Did he blow into the Soberlink on the 23rd at all?
He did, yep.
How much longer after 8 a.m.?
He did it again, so 4 hours later was the noon.
How about on the 24th?
Same with that.
At noon?
Noon.
All right, anything?
Your Honor, speaking with Mr. Wilson, Bennett, he has throughout this process, he's changed his work schedule. That is an adjustment. On the PM blows, I think he just fell asleep early. That being said, he's taken some safeguards. He now has his phone alarm set for the different 5 minutes before each blow of the day. He's now using a smartwatch, which will vibrate, which he wasn't using before for when he has his at work. And he's also got the Alexa set on his house to where it'll tell him that it's 7:55 or 3:55. That being said, on one of these also, one of the 8 PMs, he provided a urine sample this morning, as part of his drug drops. Your Honor, if this was a situation where
I don't disagree.
If this was a situation where I think he was trying to
Right.
game the system and he drank, I would have a much different argument.
I got it. All right.
I would ask you to continue to allow him to go ahead.
Anything?
I mean,
I messed up. I wasn't trying to beat the court or anything. Just
No, you just have to be a little bit more diligent, okay? 4 hours community service by April 21 and $50 in costs. You can pay that by April 21, okay?
Yep.
All right.
thank you so
Thank
much.
you very much. All right, so this was the beginning of your career there, Ms. Raptis,
Yeah.
right? All right, thank you.
Real quick, Ashley, was today the day that the couple in Ingham County, Michigan, that was in front of Magistrate Godsey, is today the day they were supposed to be in front of Judge Hillman? Let me know, please.
26W8411057. Your name?
Dustin, how?
Where were you?
I was at the wrong court. I have a ticket in Canton for an overweight ticket for work, and I took off out to Canton and thought that that was where I needed to be. And by the time I got back here, it was already too late. I missed it.
All right. I don't remember. Did you have a lawyer before, or did you waive your right to a lawyer? This is an anti-blight case.
Yeah, this is the one, you recommended that I talk to the prosecutor.
Well, I mean, if you want a lawyer, I'm going to give you a lawyer.
Yeah, I need to talk to the prosecutor.
Okay, but listen, I'm talking about a defense lawyer. Do you want a defense lawyer to represent you?
Yeah.
He waived an attorney last time, Judge.
Okay, so if you want a lawyer, I'll still give you one. If not, I'll just send you to the prosecutor to talk about this.
Yeah, I'll just talk to the prosecutor.
Okay, so you don't want a lawyer. I'm not trying to confuse you. I'm just asking. Tell you what, I'll send you to the prosecutor. If you change your mind between now and the time he comes and gets you, just come on back in and I'll give you a lawyer, okay? All right, thank you. That's Eli, isn't it? How you doing? I've been wondering when you were coming in. You don't need to, you can come in the back with us. I'm just saying, when you're coming in here, you're fine. All right, Villegas. Adriana Giselle Villegas, 26W840-321. Good morning, Ms. Acock. Your name?
Good morning, Your Honor. Leslie Acock on behalf of the defendant, Ms. Villegas, who's present to my right. Can you please state your name for the court this morning?
Adriana Villegas.
All right, so you met with the prosecutor. The prosecutor is going to dismiss the super drunk charge, and your client is going to plead to operating while impaired, true?
Correct, Your Honor.
Is that what you want to do, ma'am?
Yes, Your Honor.
If you plead guilty to that charge, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service, court costs are all those 4 points. Your license will be suspended or revoked in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes, Your Honor.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You don't have to testify at a trial. If you choose not to testify, if it goes to trial, that silence would not be held against you. You can testify at a trial if you so choose. You do have the right at a trial to question their witnesses, to use the subpoena powers of the court to bring in your own witnesses. Do you understand that?
Yes, Your Honor.
By pleading guilty here, though, you're waiving your right to a trial of any kind, jury or judge. Do you understand that?
Yes, Your Honor.
All right, to the charge of operating while visibly impaired, how do you plead?
Guilty.
Were you operating a motor vehicle in the city of Woodhaven on Western or Ford Lane in Woodhaven at 2:50 in the morning on January 10 of 26?
Yes, Your Honor.
Did you drink alcohol prior to that? And if so, what did you drink and how much?
Yes, I did. And I had 2 beers, 1 margarita, and 2 shots.
2 shots of what?
Tequila.
All right, and was your ability to operate the motor vehicle impaired due to the consumption of that alcohol? And if so, in what way?
Yes, Your Honor. In I in the way that I hit a curb on the way out and then it caused my car to break down.
You think you did that at least in part because of your alcohol consumption?
Yes.
Miss Aycock, this was this a blood draw or an intoxilizer?
Intoxilizer, Your Honor.
All right, you stipulate that the results of 0.175 were accurate.
Yes, we stipulate.
Are you on probation or parole right now, Ms. Villegas?
No, Your Honor.
Anybody force you to plead guilty?
No.
I'm going to accept your guilty plea to operating while impaired. I'm going to go ahead and dismiss the super drunk. I'm going to refer you for a screening and assessment. You're going to be screened and assessed today. So I'm going to ask you to come to the courthouse. You'll go to probation. You'll fill out a questionnaire and you'll be interviewed, and then you'll come back for sentencing. Okay?
Okay.
All right. So let's pick out a sentence date. Heather, what do you have for me?
Any interest in Courtram's school on April 30th?
Where's that one at?
Trenton High School.
I'm
Yeah,
sorry,
this,
Your Honor, I'm going to be in Wayne County Circuit Court in front of Judge Wanda Evans that morning. I would not be available.
what time is that at?
9 a.m. Me?
Yeah.
From 9 a.m.
All
And
right.
that's Courtram's school time. So we could do April 15th at 8:30.
April 15th at 8:30. Okay.
Yes, as
That
long as the court's aware. I do have a felony, a circuit court Zoom hearing at 9, so I might kind of be bouncing back and forth.
Yeah,
That's
let's
okay.
just set another day. I don't need this to be on a Woodhaven docket day, Heather. Why don't we set it on a Monday? There's no
Okay.
restitution, so
Do you want to do the April 20th? That's a landlord tenant day, but you want to put it in on that day?
or the 13th at 8:30. What's your choice?
I'm not available the 13th. The 20th, I'm open in the morning.
You are open
On the 20th, correct.
April 20th at 8:30, okay?
Thank
And
you, Your Honor.
And you can come on up here now, ma'am, okay? Good luck to you. Thank you.
Thank you.
Hurtado. Evan Samuel Hurtado, file number 26W841254A. Your appearance,
Good morning, Your Honor. Greg Boulahanis, P36431, on behalf of Evan Hurtado. Could you
Mr.
please introduce
Hurtado,
yourself?
your name, sir?
Yes, Your Honor, Evan Hurtado.
All right, so this is gonna be a plea, I'm sorry, your client pled guilty to operating while impaired. He was referred for a screening and assessment. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
Yes, I have, and there's no material additions, corrections, or deletions, just very brief elocution, Your Honor.
Sure, go ahead.
Your Honor, I just want to make the court aware that Mr. Hurtado is working full-time, he's employed full-time, and he's also attending school for global chain management. And so he's been pretty busy. He's already done as a proactive measure before the sentencing. He's done a alcohol drug awareness class to help get ahead of this. So I ask the court to adopt the recommendation of the court probation.
Anything you'd like to say, Mr. Hurtado?
No, Your Honor.
Why do I get the feeling when I read this report that you're underachieving? Maybe it's just me. You went to U of D Jesuit and you graduated, right?
Yes, Your Honor.
And you've gotten yourself in trouble now twice in a very short period of time. An MDOP, 1,000 or more, but less than 20. Right?
Yes, Your Honor.
That's a felony. You're on height of probation for that. And then you're in there and you're driving drunk and you got alcohol in the car and you got tobacco in the car and you're only 20 years old. It's time to kind of grow up here, young man. Look at me, please. I'm dead serious about what I'm telling you. You can't be doing this. You don't want to ruin your life before you get started here. 12 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as direct. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. I'm not gonna make the testing just monthly. I'm gonna make it bi-weekly for 3 months, then monthly for 3. Then on demand. Kratom, poppy seed, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. Did your first offense involve alcohol or drugs in any form or fashion, sir?
Your first offense involved alcohol.
Yes, Your Honor.
I'm gonna order outpatient substance abuse treatment here. He scored in category 4. I want you to, and have you shown your lawyer? Well, yeah, I want you to go to AA twice a week in person until you're in outpatient treatment. So you go to outpatient treatment, AA twice a week. He's gonna hand you a form. I want you to go in person. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you. When I'm talking about that, I mean probation or otherwise. Once you get in outpatient, you no longer have to attend AA or NA. Do you understand that?
Yes, Your Honor.
I'm also going to order that you go to the Victims Impact Panel. That's one night put on by Mothers Against Drunk Drivers. I'm going to order that you pay fines of $300, costs of $250, 75 victims' rights fee, $50 justice assessment. So fines and costs here amount to $675. Screening fee $60 for $735. Probation fees are $240 for $975. Cost of recovery. Cost of recovery is $150 for a total of $1,125. I'm also going to order that you serve 5 days jail. I'll give you credit for 1. I'm going to have you serve the other 4 on the court work program. $140 for that, $35 a day. Your total there amounts to $1,265. You may be eligible for early discharge if you are compliant with no prior violations within the preceding 90 days. After 6 months, you can come in here and you can file a petition for early discharge. Listen, I mean what I'm telling you. I'm not trying to make you feel bad. You have to get your life in order here. You're driving around. I mean, you drove into a ditch. You're on felony probation. You got alcohol in the car and you're not even able to legally drink yet. Come on. Don't do this to yourself. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford one. Do you understand that?
Yes, Your Honor.
All right. Mr. Bulahanis, does he have all of this to pay?
Yes, he can pay that. He can pay the $1,265 today, Your Honor. And in addition, I was gonna ask, may he come up to the court to talk to the
Yeah.
probation today?
That would be great. That would be great. So come on up, make your payment, and then you'll go to probation and they'll instruct you, okay, and provide you with a copy of the order. Come on, do better than this. I know you can. Good luck. Thank you. Thanks, Mr.
Thank you, Your Honor.
Do I have Jonathan Hubbard here? Jonathan Hubbard here? Do I have 1, 2, 3 towing and recover? Come on up here, sir. 26W841854. And I'm going to ask you to call in. Mr. McDermott, as soon as I get yours, I will call that. Your name?
Michael Shane, CHE.
Tell me you didn't drive here from Houghton Lake.
Excuse me?
You didn't drive here from Houghton Lake, did you?
Well, when I work downstate, I'm in the area.
I can't let you, this is a corporation, right?
Yes.
I can't let you appear on behalf of the corporation. I'm sorry. I just can't do it. It's not my rule. I just can't do it. You're going to have to hire a lawyer. I'll give you an adjournment, but I cannot allow you to appear on behalf of the corporation. Okay? I'm sorry. Not my rule. All right? So I will adjourn this. Oh, wait a minute. We issued a show cause against you for failure to appear and defend the corporation. This is actually going to be a show cause. Why haven't you shown up?
Because once I got back up to Holton Lake, I work down here 2 weeks, then I go back and I stay.
Did you call the court and say, can I adjourn it?
No, because I didn't know that the letter came in the mail.
Can you spell your name for me?
Cheney, and Michael, MICHAEL.
And you are the president of the corporation,
Yes, I'm the owner.
but this is a corporation, right?
Right. Well, it's an LLC, but
I understand. So listen, what I'm gonna do is I'll adjourn this, but you need to hire a lawyer. I'm not trying to make lawyers money, but I can't let somebody appear on behalf of a corporation except a lawyer, okay?
all right.
So, is 2 weeks enough time to give you to go get a lawyer?
Yes,
We have April 15th, right, Heather?
That's correct.
You want me to make it a little later in the morning for you?
yes,
How about 10:30? Is that good enough?
that's good.
At 10:30, so, you hire that lawyer. We will give you a notice down the hall, okay? Can you call in the prosecutor for me, please, Sadie, 249? And you're all set. All right?
Thank you.
All right, good luck.
Pause real quick in the action. I'm using pause a lot lately, but maybe that's a good thing. We've seen this a couple of times in Judge McNally's court now, where somebody shows up to represent themselves as it pertains to their LLC or corporation. So I looked this up. In Michigan, a corporation or an LLC must be represented by a licensed attorney in most courts, district or circuit, even if the owner is the sole member. Non-lawyer owners officers cannot represent a corporate entity, as this is considered unauthorized practice of law. And it is actually MCL 450.681. It shall be unlawful for any corporation or voluntary association to practice law or appear as attorney at law for any person other than itself in any court in this state or before any judicial body. So that sounds to me like a law that was written by the lawyers to make sure they had more business. But yeah, even if it's an LLC and you are the only member of that LLC, you cannot represent yourself in the state of Michigan. Back to it.
Judge, we also do have one in Calhoun County Jail.
Who's
And he's
representing who's representing him?
Mr. Crawford, he's already
Where's Mr.
met with
Crawford at?
him. He's on Zoom here also.
Okay, let's take this real quick. Derek Schultz, Derek Michael Schultz. I have 26W841842A, B, and C. I'm gonna need Mr. Urick in about 10 minutes, Lieutenant, okay? Where is Mr. Crawford? Mr. Crawford, your appearance. Mr. Crawford, your appearance, sir.
Shows that he's out here.
You have McDermott's file, Mr. McDermott.
Sure, was it a final?
Mr. McDermott, what case do you have, sir?
Dylan Jacob Barden, Judge.
What do you prosecutor is that?
Did you talk to the prosecutor already?
Yeah, we just need an adjournment so my client can take a driving class.
I don't know why they keep sending me that nonsense. I'm gonna call him in on that too. I don't either. But I'd like to get this gentleman out of the county here.
Barden.
He just poked his head in for about 7 seconds. And Dylan Jacob Barden, 267841449 A and B. I know.
Sean McDermott, on behalf of Mr. Barden, Judge, I have spoken to the
Hang on one
prosecutor.
second. Mr. Urick, your name?
William Urick on behalf of the city of Woodhaven, Your Honor.
What do you want, a traffic? What, I don't want to do these classes. He's going 38 and a 25, right?
Well, the issue was, Your Honor, and I apologize for leaving my code.
That's okay.
It's from The issue was, Your Honor, that he blew a number of stop signs before the officer finally cited
We
him.
really need, these traffic classes, I'm sorry. Do we need a traffic class to tell us that we're not supposed to run through stop signs? I mean, what planet would you have to be on to have to go to a traffic safety school to know that you don't run stop signs? I just don't believe in these classes. I'm sorry. If you want to play a harder role, that's up to you. You guys, but I don't want to adjourn these out and have these guys go do.
If we could set it for a formal then, Your Honor, it would serve the same purpose.
How long is it going to take them to get through the class?
Inside 30 days, Judge.
Why is he?
So the issue is the young man, who is a young man, had a hazardous action on a moped.
Where's he at? Where's he at? I think it would be nice for him to be here next time. He doesn't
I can
have
have
to
him,
be,
Judge.
but
I
I'd
can
like
have
to
him
talk
available.
to him if he's going to drive like this. Maybe he needs to push the car. So I'll go ahead and adjourn it
Thank you, Judge.
for 4 weeks. But that's it, though. Okay, and I really want your client on Zoom next time, Mr. McDermott. Okay.
He'll be there, Judge.
All right. Adjourn it to the 29th. Is that going to give everybody enough time?
Yes, Judge.
I just don't want Mr. Zurich. We'll do it at 9:00, okay? April 29th. I just really don't want to do these class things, okay? I really don't, in the future, all right?
Understood, Your Honor.
Okay, so I'll make this one April 29th. Thank you. People against Schultz, Derek Michael Schultz, 26W841842A and B and C. Mr. Crawford, your appearance.
Good morning, Your Honor. Michael Crawford representing Mr. Schultz. Mr. Schultz, please state your name for the record.
Derek Michael Schultz.
I have a possession of a controlled substance charge. I have a possession of drug paraphernalia, and I have a retail fraud charge. As I understand, first of all, does he stand mute and waive formal reading on those?
Yes, Your Honor.
All right, so I'll enter not guilty pleas form. Now, as I understand, he's going to plead guilty to possession of drug paraphernalia and attempted retail fraud. Is that true?
That's correct, Your Honor.
All right. And, sir, state your name again, nice and loud for me, please.
Derek Schultz.
All right, so if you plead guilty, did you hear what your lawyer said?
Yes, Your Honor.
If you plead guilty to drug paraphernalia possession, the possible penalties are up to 500 fines, 90 days jail, costs, or all those. If you plead guilty to attempted retail fraud, the possible penalties are up to 250 fines, 45 days jail plus costs, or all of those penalties. Do you understand that?
Yes, Your Honor.
And if you plead guilty to those two charges, I'm going to go ahead and dismiss the retail fraud charge on motion of the prosecutor. And I'm also going to dismiss the possession of a controlled substance on motion of the prosecutor. If you understand that.
Yes, Your Honor.
Now, you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to trial by court or jury. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. Mr. Crawford, what are you doing? Are you
I'm
on
listening,
something
Your
else?
Honor.
Are you on something else?
No, Your Honor.
I thought you were talking to somebody. I didn't know.
I'm looking at a file while I'm listening to you, Your Honor.
Okay. If you plead guilty, you're going to be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, Your Honor.
You understand you're waiving your right to a trial by pleading guilty. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
All right. To the charge of possession of drug paraphernalia, how do you plead?
Guilty, Your Honor.
To the charge of attempted retail fraud, how do you plead?
Guilty, Your Honor.
Were you in the Home Depot store on Allen Road in the city of Woodhaven on February 3 of 26 at
Yes, Your Honor.
8:13 p.m.? Yes?
Yes, Your Honor.
And were you in possession of drug paraphernalia? And if so, what were you in possession of, and what did you use that paraphernalia for?
Yes, Your Honor. It was a water pipe for LSD.
All right. And did you commit the offense of retail fraud?
Yes, Your Honor.
So I'll ask you again, to the charge of retail fraud, how do you plead?
Guilty, Your Honor.
Did you attempt to take property, or did you take property that was offered for sale without paying for it, the intent to permanently deprive the owner, Home Depot, of that property?
Yes, Your Honor.
What did you take?
I didn't take nothing, but I was going to take some drill bits.
Some what? Drill bits?
Yeah, but I didn't take them.
Well, you must have taken something, right, or not? You didn't put those in your pocket or conceal those initially in any way?
Yes, Your Honor. I did,
But you
but
didn't
I
get
took
past the
them out
point, hang on, slow down, but you didn't
Oh,
get past the point of, where did you put those?
in my pocket, sir.
All right, and then, but you didn't get past the register, I think is what you're telling me, correct?
Correct. Yeah, correct, Your Honor.
Somebody apprehended you in the store before you got
Yes, sir.
past the register?
Yes, Your Honor.
But at the time that you put those items in your pocket, did you intend to deprive Myers of Home Depot of that property?
Yes, Your Honor.
Right now, are you on probation or parole?
No, Your Honor.
Anybody force you to plead guilty or promise anything to induce you to plead guilty other than a dismissal of the controlled substance charge and retail fraud charge?
No, Your Honor.
Okay, I'm going to find the pleas have been made voluntarily and understandingly. I'm accepting the plea to attempted retail fraud and drug paraphernalia. I'm dismissing the retail fraud charge. I'm also dismissing on motion to prosecute possession of a controlled substance. Why is he in custody and for how long, Mr. Crawford?
Your Honor, my client is in custody for another drug possession charge, Your Honor. It's pending. He's in the process of working out a plea agreement there, but it's based upon getting things at least resolved here, Your Honor. My client admits he's got a drug problem. He's trying to get into drug treatment. He's taking responsibility for that by pleading guilty now and to the other matter. He's been in custody now already, Your Honor, for 2 months.
That happened after this case or
Yes, Your
before?
Honor.
Yes,
It
Your Honor.
happened. It happened before this case, Your Honor. But the warrant came out when I got picked up for this case. They picked me up from Woodhaven.
Do you live on Buff Street in New Haven?
No, I live in Rochester now.
Okay, can you give me the address?
591 Lesperance Drive.
You're gonna have to spell that. Hang on. 591 what?
Lesperance, Lesperance.
Lesperance Drive in Rochester Hills, is it?
Yes, sir. 48307.
What kind of a bond does he have on that case, Mr. Crawford, out of Calhoun?
Your Honor, I'm not exactly sure. Sir, could you state what your bond is?
25,000
Cash?
cash.
Would the court consider sentencing my client to the time served?
This is a bad record.
Well, he's got a drug problem, Your Honor. He's been plagued with it for some time, and he's trying to get it in order now, but he doesn't deny it.
Yeah, I've never been. I do have a record. It's from the past. Like
Well,
way in
everything's from the
past.
past. Of course, you're not convicted of anything from the future yet, but you've got cases dating back to 06.
Yeah. I'm trying to go to.
You've had 20 years to get your act together and you're not doing it.
I recently went through a divorce a couple years ago and kind of fell off the deep end. I'm not making.
Well, you've been off the
excuses
deep
for my
end as
actions,
far as
but
I can tell since 05 or 6. I mean, not many women are gonna want to stay with somebody that's constantly in prison or jail. I mean, they're out there, they'll still do it, some of them, but this
That's why I'm
record's
trying to
bad.
get
All right,
rehab.
look, I don't want to sentence him. I want to look at this. I'm not going to order a pre-sentence report. Let me think of what I'm going to do here. When is Mr. Crawford here again, Heather? Are you here in 2 weeks?
I should be, God willing.
Yeah, Judge, he is our Woodhaven House Counsel.
I'm gonna do sentence date April the 15th. You tell me what's best time for them to put him before a camera if you know.
They seem to be, I just notified them on Friday of this date because I was notified he was in Calhoun County, and they got him on today, so they seem to be pretty flexible.
Well, what time do you want it? What time did you set this one?
8:30.
Well, let's do the same, 8:30. Boy, you got to get your life in order. You're only, what, 38? Pardon? 37?
Your Honor.
I'll just let it go with that. I would like to see, Heather, if we can get something just confirming he's in custody on that and has been for whatever length of time on that 25,000 cash bond. But I'm not ordering a screening. I'm not ordering a pre-sentence report. Good luck. We'll see you back
Judge,
here.
do you want to put a bond on this one?
Oh, I forgot to do that. Thank you. See, that's a good thing, Mr. Crawford. You surround yourself with smart people.
Absolutely.
And then they can correct your mistakes.
Absolutely.
Good job, Heather. All right. I'm going to make it. Thank you very much for reminding me. All right. I'm going to give you a personal bond, $5,000. Don't take that the wrong way. I'm probably just going to end up giving him credit for time served. It sounds like he's got a lot of other fish to fry here.
Yes.
No alcohol or controlled substances. Not to enter any Home Depot. Not to enter any Home Depot. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Also, again, so no alcohol, no illegal drugs, no marijuana, do not leave the state, cannot violate a law. You must appear in court as directed. You're not to go near Home Depot, any Home Depot. Do you understand that?
Yes, Your Honor.
We'll sentence you in a couple weeks, okay? Thank
Yes,
you.
Your Honor.
Let's call him in.
All right, apparently the precogs are offline this morning. As a few minutes ago, Judge McNally confirmed there are no future crimes being heard in his court this morning. Good morning, everybody. My name is Dan. Welcome to TCF. Judging by the stats, there are a few new people out there. Please do say good morning to us in the chat. Let's change it up. Let's go down to Florida, see what's going on with Wade Mercer.
Count of aggravated child abuse. Ms. Rich, there is probable cause for the charge. I'm the judge that was asked to review the warrant and sign it. Mr. Jackson, I found probable cause, but I felt like it was very close to a regular child abuse. But I thought there was enough for probable cause. I have no idea how the state will choose to go forward with it when they get a chance to review it. I also looked at your criminal history, which had one prior battery that was dismissed. That's the only thing I saw. So, Mr. Axon, anything on behalf of Ms. Rich that you want to make sure I'm aware of?
Your Honor, other than her lack of criminal history, she is also a Jackson County resident. She has multiple minor children, one of which is, I believe, placed by DCF, and I think that's the victim in this case. We would ask that she would be able to have contact as allowed by DCF with that minor child. She also has I believe, two other minor children who have not been placed by DCF, so they're still in her custody. And so we'd ask for no violent contact for them minor children. We would also ask for a low bond. I don't believe she's a flight risk based on those, and she's not a danger to the community.
Is there a case plan involved with the other children?
Your Honor, I've not gotten involved with the DCF case, so I'm not sure on that at this point.
Do you mind if I ask your client that question?
I have not.
If DCF's got other restrictions involved in other children, I'm probably just going to say the same thing, comply with the DCF case plan.
Okay.
Ms. Rich, is there a case plan involved in the other children?
There's a safety plan in the ones that are removed and not the ones that are with me to my knowledge.
Okay, I'm a little confused because I understood there to be only one removed. How many children have been removed?
Well, now I have not received removal paperwork on any of them.
Okay.
But DCF did place my 5 older children with their dad for the investigation.
Okay. And then how many other children did they not place with him?
2 that are with me.
Okay, and of those two, there's a safety plan, a voluntary safety plan in place. Is that right?
Yes, yes, I believe
Okay.
so.
Where you agreed to X, Y, and Z, and they said, okay, we'll keep an eye on things, that kind of a deal, right?
Yes, sir.
And the only history you have is that one battery case that was dismissed, correct?
Yes, sir.
Okay, Mr. Mitchell.
We will leave the amount of bond up to the court, but as for the contact, we're not in objection to no violent contact as long as she adheres to whatever safety plan or DCF plan is in place.
Okay. So if it had been with no history, if it had been regular child abuse, not aggravated, it would have been a second degree felony or third. I need to look at that statute.
Child abuse,
I
think it's a third degree.
I think that is correct.
So because this says first degree on aggravated, which means it would jump up 2 degrees. And if that's accurate, it is. I have no idea. We're going to find out though. So child abuse in Florida is 827.03. The degree of the crime usually affects the bond, ma'am, the way I set bonds. So let's see, 827.03. Aggravated child abuse, you're charged under subsection 2A. Is a first degree. Regular child abuse is a third degree. So it jumps from third to first. You're both right. Okay. Anything else, counsel, before I address the bond?
Nothing further. Your Honor.
So what I'm gonna do, Ms. Rich, this is very close to regular child abuse allegations. I felt like there was sufficient probable cause, but again, it's a close call. So I'm gonna treat it for, with your lack of history, I'm gonna treat it for child abuse, as a child abuse for bond purposes only. That means your bond's gonna be $5,000 cash or surety. You can go through a bondsman, or you can put up all 5,000 if you wish. That's entirely up to you. You're going to have a condition to have contact with the children only in compliance with the Department of Children and Families as outlined in a case plan or other court order. So if they have an active case plan and you're complying with that, I have no problem with that. They know more about the situation than I do. Also, if the child has been removed, but they allow some type of visitation that's approved, I have no problem with that. Again, that's their area, not mine. So as soon as that bond is posted, you'll be released. I'm going to ask the jail to give you a notice for your court date. What would her arraignment date or pre-arraignment date be?
It's a May. I know that one. May 5th.
May 5th. So Mr. Axon, I don't know if you've had any of these since we started doing this at first appearance, but Judge Garcia and I, we've started giving tentative arraignment dates, especially as a tracking mechanism at first appearance. So our court date will be May 5th at 8:30. Now, obviously, if you file a notice of appearance, that may move that date.
Yes, Your Honor.
Mr. Axon, anything else?
Nothing further, if I may be excused.
Yes, sir. Mr. Mitchell, anything?
Nothing else from the state. Your
And
Honor.
Ms. Rich, do you have any questions?
No, sir, I don't believe so.
Judge, she did ask me about a cash bond. I don't know if that's an option or not, so I'm just gonna go ahead and let the court know.
Mr. Mitchell?
Wes, do you want to know?
If she can post to like a $500 cash bond, I mean, I don't know if she can get a surety bond for $500, I'm sure she can post a cash bond for $500. I don't know what the
Mr. Mitchell?
position is.
No objection to that. I
don't mind giving you that option to your bond to be $500 cash. Would you prefer that, Ms. Rich?
Please.
It's the same amount. It just means you don't go through a bondsman. You just put up all 500 cash, and that's not negotiable. If you go through a bondsman, they may take a certain amount up front, but if you post a cash bond, it's got to be all 500. Is that what you want to do?
Yeah, actually it is.
Okay. Your bond's $500 cash as agreed to by the state and defense. All right, man. Wish you the best. Thank you, Mr. McDaniel.
Thank you, Your Honor.
Thank you, Mr. Axon. The next case that has friends or family here is number 2 on the docket. That's Sammy Butler. Mr. Butler, good morning. Mr. Butler, your mother and your niece are both here. Mr. Butler, you're here in case 25-121 CT. Mr. Butler, you're accused of violating the terms of your probation. But I made the attorneys aware yesterday by a text or email that you work for my father-in-law. And because of that, I have no problem getting another judge or recusing myself if either side wants one. On the other hand, if y'all worked out some kind of agreement, then I have no problem doing that. Also, if both sides are willing and want to waive that conflict. Mr. Mitchell, do you want another judge to hear this, or are you okay with me hearing it, sir?
I am okay with you hearing this one.
Mr. McDaniel?
No change from the last hearing we had, Your Honor. I think you made us all aware then, and we still don't have a conflict.
I think Mr. Butler's helped me load some corn before when I've got out there, gone out to pick out some corn for deer hunting. Mr. Butler's about as strong as a mule. He pick up 2 of them bags and I struggle to pick up 1. But anyway, that's really not relevant today. So Mr. Butler, appears there's no conflict. There's any potential conflicts being waived. So listen to Mr. McDaniel. I'm appointing his officer to represent you. We're going to see where we go.
Your Honor, I spoke to Mr. Butler. He's going to go ahead and admit that he violated the probation. Understanding he's going to be sentenced to 10 days in the county jail, 5 days jail credit. He's already paid the fines and costs, so that'll resolve this case today.
Mr. Mitchell.
That is agreeable with the state, Your Honor.
So ladies in the courtroom, he did everything on probation he was supposed to do according to Mr. Goodson, right, Mr. Goodson?
Yes, sir.
Including paying all his court costs and fines of $1,700, except he did not go to counseling.
Yes, sir. That's
So
correct.
That's why I feel like there's a need to do something to him, and that's where the 10 days comes from. Mr. McDaniel, have y'all discussed when is he going to go ahead and do the sentence now, or is he going to come back later and finish it because of the planning season?
I assume he's just going to go ahead and finish it now, Your Honor. I mean, but I didn't discuss it with him, but he should be out of here. Today will be the 6th day, so within the next 4 days probably, and he may get a day off of it, so.
Mr. Butler, I don't mind, and I told the attorneys this, if this works out and they decided to waive any conflict, that I don't have a problem with you coming back. I know it's your corn planting season, but if you want to go ahead and finish it now, that's okay. You would have 5 days left, Mr. McDaniel, or 4 after today?
So after today will be the 6th day when they put it in the system, so you have 4 days left.
So you can either go ahead and just stay and finish that time, Mr. Butler, or you can come back in a few weeks when you get through with the planting season and finish the time then. I have no preference. Do you have a preference?
He said Sunday morning, you may get a day off. I mean,
If he shows up like on a Friday afternoon, then he would actually, he's probably not working the weekend anyway. I don't know if they work weekends this time of year.
I mean, if he were to start today, he might be out by Saturday or Sunday.
Go ahead, Mr. Butler.
If I leave today and I come back like you said, on a Friday, I can just go through the weekend.
Well, we'll pick some in the next few weeks. We'll pick a day go ahead and pick a day today, so you'll know a day to come back. And we try to have these individuals turn themselves in these kind of situations no later than noon, because we've got the day shift at the jail working. So you would show up on, let's say, Friday at noon. You get credit for that Friday. You get credit for Saturday, you get credit for Sunday, and you would get out on Monday or Tuesday, depending upon how the math works. Mr. McDaniel's figured that.
Mr. Ham just sent a message to all of us in the perseverance list saying corn has already been planted. I don't know if that's relevant.
Mr. Ham told us that he had been spraying it or something. He was supposed to spray it yesterday.
Yes, sir. I think they got the corn planted, but he was in the process of treating the corn. Yes,
I may have misspoke when I said planting it. It may have been something else. I don't know. If you want to go ahead and do the time, that's fine. If you'd rather come back later, that's fine. What would you rather do, Mr. Butler?
If I get out there, would I have to have a bond?
No, you just got to come back.
Just have to come back. And if I come back, I still have the regular 5 days or 4 days.
It's going to be the same sentence. You're going to serve the same amount of time. It's just when you serve it is the only difference.
Okay, because I really need to get back to work. I think I'll come back.
So when would be a good time for you to come back? I can go, we can go out a few weeks, we can go out a month. I'm not going to put it off 6 months, but.
I'll say about 3 weeks, because I got to finish doing treating all my corn and stuff.
Would you rather it be on a Friday?
Yes, sir.
So if we go out 3 weeks from this Friday, Ms. Williams, what day would that be?
April 24th.
April 24th. Does that work, Mr. Butler?
Yes, sir, that'll work.
Mr. Mitchell?
No objection.
Mr. McDaniel?
It's good, Your Honor.
Mr. Butler, I'm going to accept your admission that you violated the terms and conditions of your probation. This is a plea you would like to enter, correct?
Yes, sir.
I'm going to accept your admission that you violated the terms and conditions of your probation, Mr. Butler. I'm going to revoke that probation. I'm going to sentence you to 10 days in jail. You did 90% of what you're supposed to do on probation. I'm going to revoke that probation and sentence you to 10 days in jail, but you have credit for the purposes of the plea, it would be 5 days, Mr. McDaniel. You have 5 days credit for purposes of the plea today. You're going to complete that sentence by turning yourself in April 23rd. April 24th, no later than noon. Mr. Butler, April 24th, you need to be at the jail by noon. Now, what I'm going to do is I'm going to give your family in the courtroom, I'm going to give we have your niece here. If it's okay, we're going to give your niece a copy of this paperwork showing the day to be back in jail, at the jail, and then you need to take that paperwork with you when you show up at the jail. When he shows up at the jail, April, he needs to take this paperwork with him, okay? Okay. Mr. Butler, they're going to pick you up. They're going to process you out. Ladies, it's usually about a 30-minute deal to get processed out. He can be picked up in roughly 30 minutes, okay? Mr. Butler, do you have any questions?
No, sir.
I wish you the best, sir. Does the family have any questions? Oh, all right. Wish you the best. Thank you. And I think there may be another young lady coming on your case too. Are you here on that case too, ma'am? I don't think I announced that because when I asked earlier, you weren't here yet. So I can. Okay. Your girlfriend's here. All right. Wish you the best, sir.
Okay, thank you.
Yes, sir. You might choose to just stay there. Thank you, ladies. All right, so the next person that has friends or family here is Mr. Bell, Jeff Bell. Just like, ladies, we'll give you a copy of this paperwork, okay? Mr. Bell, your wife is in the courtroom. You're here in case 26-122 CT. And Mr. Bell, I believe there's a bond already set on that warrant. And Mr. McDaniel, any action we need to take in this case? So, Mr. Bell, we're going to give you a notice. I'm assuming you're going to post bond. Hopefully, you're going to post bond. And I apologize. I should have told you yesterday when we took you into custody in the courtroom, there was a bond on the warrant. And I just forgot.
You did.
Oh, did I?
Yeah, you did.
Good. So there's a bond already set. That bond is $2,500, Mr. Bell. We're going to give you a notice. Do you anticipate being able to post the bond? Okay. Your wife's saying you're going to try to post the bond. So we're going to give you a notice for the arraignment docket, which would be when, Don?
27th.
The 27th of March.
Yes, sir.
27th of April, because 27th of March already passed. 27th of April will be your court date. They're going to give you a written notice at the jail, Mr. Bell. You will not get a notice in the mail. That notice they put in your hand will be the only notice you get, 9 a.m. on the 27th. So you'll get to use the phone in a few minutes to post the bond. And the only special condition of the bond is don't drive a motor vehicle unless you have a valid license. If you get your license fixed, then you drive. That's fine. But if you get caught driving without a license, that will violate your bond, and we'll see you on your court date. Mr. Bell, do you have any questions?
Yes, sir.
All right, sir. Wish you the best. Ma'am, do you have any questions?
Yes, sir. You too.
Thank you. Thank
Yes,
you.
sir.
We have Jasmine Primus. It was a $2,500 bond.
Yeah.
I looked at it this morning. And Ms. Primus, good morning. Your brother is in the courtroom. Ms. Primus, you're here because you've been accused of one count of fraudulent use of a credit card, one count of grand theft between $750 and $5,000, ma'am. There is probable cause in the complaint, Ms. Primus. And I'm going to listen to the attorneys before I address your bond status. Mr. McDaniel, anything?
Your Honor, Ms. Primus just maybe probably just ask for a cash bond if that's an option.
There is allegedly restitution owed, Mr. Mitchell.
She wants to post cash bond. We don't have any objection.
Ms. Primus, did look at your criminal history. You had a couple things on there. I'm going to set you a $500 cash bond on each of these felony charges. Ms. Primus, that means you've got a total bond of $1,000 cash. Ms. Primus, as soon as that bond is posted, you'll be released. So let me talk to your brother. So, sir, she's got a $1,000 cash bond. The good thing about a cash bond is, let's say the charges are dismissed. If they're dismissed, that money's returned to whoever posted it. On the other hand, if they're not dismissed and she's ordered to pay restitution, that money can go towards restitution. So that's why a lot of times the state and defense both want a cash bond, because they want that money to be there in case it goes one way or the other. Okay. But as soon as that bond is posted, she'll be released. We're also going to give her notice for a court date, and her court date will be when? May the 5th will be your court date. They'll give you that notice at the jail, ma'am, and that'll be at 8:30. That'll be in front of Judge Garcia. Ms. Primus, do you have any questions?
No, sir, Your Honor. I just wanted to apologize.
Ms. Primus, I wish you the best. Sir, do you have any questions? Thank you for coming. That's right. At the jail. At the jail. Penn Avenue. Yes, sir. Take care of yourself. All right, so that's it for friends or family. Mr. McDaniel, we can start back at the top of the list, which is Thomas Racanello. Mr. Racanello, good morning. Mr. Racanello, you're here because you've been accused of one count of written threat to do bodily harm, one count of criminal mischief over $1,000 and a misdemeanor resisting an officer without violence, it appears you're already out on bond in 26-15 CF. There is probable cause in the complaint for the new charges. Mr. Racanello, I'm going to listen to the attorneys and I'm going to address your bond status. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
Your Honor, like you said, he is out on bond in 2615 CF. That case actually has a condition of random UAs. In addition to setting the bonds for these new law cases, we were requested to be drug tested at the jail just to see if he has anything in his system.
I like to think I don't miss much. I think I probably do, but I didn't even catch that. So I appreciate you catching that, Mr. Mitchell. So yeah, if he's got a condition of random urinalysis, corporal or sergeant, I think it's a sergeant this morning, we need to get a urinalysis after first appearance because Judge Garcia likes to know that, and it may actually help him if it's negative or anything. So Mr. Racanello, I'm gonna set your bond at $15,000 each on the 2 felony charges, $5,000 on the resisting. That's a total bond of $35,000 cash or surety. You have a condition of no contact with the alleged victim. Do not try to post the bonds because I'm going to revoke your bond in 26-15 CF. So you now got no bond in that case. So what that means is even if you posted the new bonds, you wouldn't get out because you've got no bond in the case you're already out on bond on, and they're going to give you a urinalysis after first appearance. Mr. Racanello, your court date on these new cases will be May the 5th. May the 5th at 8:30 will be your court date on the new charges in front of Judge Garcia. Mr. Racanello, do you have any questions?
No.
All right, sir. I wish you the best. We have Alejandro Trinado. I may be mispronouncing that last name. Mr. Trinado, good morning. You're here because you've been accused of one count of driving under the influence. I've read the complaint. There is probable cause. I looked at your criminal history, which I think you had no prior criminal history, maybe a driving while license suspended that was dismissed years ago. And that's it. So, Mr. Trinado, I'm appointing the public defender's officer to represent you. I'm asking that you listen to Mr. McDaniel, your attorney.
We're going to plead no contest. The charges listed in standing, 1129 probation, $1,078 in fines, 50 hours of community service, DUI, school minimum driver's license suspension, AA classes unless he completes some of the DUI classes. And he's waiving his right to jury trial and call witnesses, and that'll resolve this case today.
Thank you, Mr. Mitchell. Is that agreeable with the state?
It is, Your Honor, and I will point out that it does look like his BAC was a .164, but for purposes of first appearance and given the fact of his lack of criminal history, we'll stipulate to it being under .15.
I'm sure you're okay with that, Mr. McDaniel.
Yes, Your Honor.
Mr. Trinado, did you hear that plea agreement, sir?
Yes, sir.
Any questions about that agreement?
No, sir.
Is that the plea you would like to enter?
Yes, sir.
Sir, I'm going to accept your plea of no contest to the charge of driving under the influence. I'm going to find it's freely and voluntarily entered, but specifically you're pleading to a blood or breath alcohol of less than .15. That's important because that removes certain mandatory conditions under Florida law. I'm going to judge you guilty of that offense, sentence you to 11 months and 29 days probation, standard court costs and fines. I may have already said that. The $1,078. Successfully complete DUI school and substance abuse counseling. The substance abuse counseling, if you do enroll in DUI school within 60 days, that will constitute your substance abuse counseling. That'll take care of it. If not, you can choose to do 12 AA counseling sessions or private counseling if you prefer until that evaluator relieves you. 50 hours of public service work. I do recommend the minimum driver's license suspension. Mr. Trinado, what's going to happen next? If they're going to let you use the phone, they're going to let you get dressed in your regular clothes. The reason for using the phone is in case you want to contact friends or family for picking you up, transportation purposes. Then after you do that, they'll bring you to the courthouse to meet with the probation officer. Mr. Goodson or Mr. Ham will meet with you. I believe this will be Mr. Goodson's case. He will answer any questions you have about the probation. He'll give you a copy of the rules in writing. He also will answer any questions you have about the driver's license issue, and then you'll be free to leave. So if you do call friends or family, you can tell them that you can be picked up in about 30 to 45 minutes from now at the courthouse in Mariana. Any questions, sir?
No.
All right, sir. Wish you the best.
Thank you.
Yes, sir. We have Hansford Griffiths. Mr. Griffiths, good morning. Mr. Griffiths, You're
Good
here for
morning.
first appearance. Good morning. You're charged with one count of driving while license suspended or revoked habitual and one count of failed to register a motor vehicle. There is probable cause in the complaint, and it looks like you just got out of prison for the exact same charge of driving while license suspended or revoked habitual. And it looks like you have 3 of those within the last couple of years, habitual, felony, driving while license suspended. So all of those are
Yes, sir.
factors for bond purposes. I'm going to listen to the attorneys and then we'll set the bond in your case. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
Not from the state, Your Honor.
Okay, Mr. Griffiths, I'm going to set your bond at $15,000 on the driving license habitual because of your history and you just got out of prison for the same thing. $5,000 on the failed to register motor vehicle. Your total bond is $20,000. Mr. Griffiths, your bond has a condition you not drive a motor vehicle. So you'll get a chance to use the phone in just a minute, sir, and you'll post that bond. If you can, you'll be released. They'll also give you a written notice after first appearance. Your notice will be for your court date in front of Judge Garcia, and that will be May the 5th. May the 5th also at 8:30. Mr. Griffiths, do you have any questions?
No, sir.
All right, sir. I wish you the best. Winston Goodson. Mr. Goodson, good morning. You're here because you've been accused of one count of grand theft between $10,000 and $20,000, one count of burglary of an unoccupied conveyance, and a criminal mischief of less than $200. And I believe you're on probation in case 23-276 CF. Mr. Goodson, I'm going to appoint the public defender's office to represent you for first appearance purposes, and I'm going to ask that you listen to the attorneys before I set that bond. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
We just request that you put a 7-day hold for the VOP case.
Mr. Goodson, I don't know if I said it or not, but there is probable cause in the complaint. Your bond's going to be $10,000 each on the 2 third-degree felonies. That's the grand theft and the burglary. $5,000 on the criminal mischief. Your total bond is $25,000 cash or surety, but don't try to post it because you are on probation in that case number I mentioned, which means I'm going to ask Mr. Mitchell to notify the probation office, and you have a 7-day no bond hold in that case. We'll see if they have a warrant within 7 days. If they do, we'll see if they put a bond on it or not, okay?
Yes, sir.
Have a good day, sir. I did not, but if you remind me when he comes back for that 7-day hold, we'll give him a court date then.
He's right here.
Is he still there? We're
Yeah,
going to
he's
give him
right
a court date then. So Mr. Goodson, your court date will be May the 5th also? May the 5th at 8:30 will be your court date. They'll give you that notice, sir, okay?
Yes, sir.
We have Noah Phillips. Mr. Phillips, you have a warrant out of Gaston County. I'm looking at the teletype, which is basically an electronic email sorta from the Gaston County Sheriff's Department. It says there's no bond on this. Now, that doesn't mean that you won't get a bond when you get there. I don't know enough about the case to tell you if you will, but you clearly don't have a bond right now. Gaston County is going to pick you up. They're right next to us, as you may know, so they're probably going to get you today's Wednesday. My guess is they'll get you this week. But if you're still here in 15 days, you'll come back to first appearance and we'll see what's going on. That's very unusual. I don't know that's ever happened with Gaston County. There's a good chance they're going to pick you up within the next couple of working days. And when you get picked up, you'll go to another first appearance over there. Any questions?
No, sir.
Have a good day, sir.
You too.
Thank you. We've already seen Ms. Primus. We've already seen Ms. Rich. That brings us to Mr. Buggs, Darrell Buggs. Mr. Buggs, good morning. Mr. Buggs, you have 2 issues. You have a fugitive warrant out of Houston County, Alabama, and then you also have a local charge in Jackson County resisting an officer without violence. I'm appointing the public defender's office to represent you in that case. I'm asking that you listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Mr. Buggs. We're going to plead no contest to the charges listed. The understanding if he sits 90 days in the county jail, get a $370 fine. He has waived his right to a jury trial and call witnesses and how to resolve this case this morning.
Thank you. Mr. Mitchell's that agreeable with the state?
It is, Your Honor.
Mr. Buggs, did you hear that agreement, sir?
Yes, sir.
Mr. Buggs, do you have any questions about that agreement?
Also, one other thing, Your Honor, that any plea here can't be used against him in any violation of state probation case.
Does he have a VOSP? Is that what the Houston County charge is?
He has local probation here in Jackson County, 25, 225. I don't know what the stuff in I don't know what stuff Dothan is.
Okay, so, Mr. Mitchell, is that all agreeable with the state?
Yes, Your Honor. What's the current one? What's that case number?
25225.
2225.
So, Mr. Buggs, Mr. McDaniel's trying to protect you. They can always use the incident, but they can't use what you're doing today against you. That's what he's putting on the record. If they try to do that, I would let them withdraw. I would let you withdraw this plea because we don't want you to hurt yourself today. If they're going to violate your probation by calling witnesses, they have the right to try to do that and convince the judge you did it, but you wouldn't plea. People wouldn't plea if pleading is going to hurt them. So any questions about this agreement your attorney put on the record?
Yes, sir.
Is this a plea you would like to enter to resolve this misdemeanor charge?
Yes, sir.
Mr. Buggs, I'm going to accept your plea of no contest to the charge of resisting an officer without violence. I'm going to withhold adjudicate you guilty, sentence you to 90 days in jail, give you credit for the time you served already, which was 1 day, Mr. McDaniel.
Yes, Your Honor.
370 court costs and fines are imposed. As a condition of this plea, if the state tries to use the plea, what you did today against you, I will let you withdraw this plea. And typically they won't do that. They'll just, they may or may not try to use the incident, but they won't use the plea itself. So, Mr. Buggs, if they haven't put a hold on you or served a warrant on you for VOP, by the time you finish this sentence or get near the completion of this sentence, Florida will notify, Jackson County will notify Alabama. And if Alabama still wants you, they'll be told to come get you. If you do have a hold from violation of probation, then you'll know about it. You'll come back to first appearance and we'll get you an attorney appointed if you ask for one and go through that process. Right now, we don't have that hold. Mr. Buggs, do you have any questions?
No, I should have that problem.
Thank you, Your Honor.
Yes, sir. Mr. McDaniel, that's everything I had on my first appearance list. Anything else from the PD's office?
No, Your Honor.
Thank you, Mr.
Alrighty, friends, TCF Live on a Wednesday. It's good to have you all here with me. What do we got, another 2 hours or so? Very cool. Let's go to Lake County, Ohio. Judge O'Donnell, see what's going on there.
Charges contained in the probation violation. Thank you.
Is that correct, Mr. Hobbs?
Yes, sir.
All right, what's your plea to the violations?
Oh, guilty.
I'll accept your guilty plea and find you guilty. Well, what's the story?
Your Honor, you know that was, I'm human, so I make mistakes, but this was one of the dumbest mistakes that I've made in a long time. I was on a very good path. I still feel I'm on a very good path, you know what I'm saying, to change my life around. It was really stupid. It was, I got no excuse for it at all. Like, and the fake urine, that was just me just trying to not diminish the 18 months of good that I was doing. I was, you know, I had a job. I had a job getting $20 an hour. I was from 9 to 2. Like, I had something to do. I was taking care of my mother. Like, every little incident that happened, I was there for it, you know what I'm saying? So I had time to, like, do that. My sister died, you know, she died in my arms. So she's not here no more. That was my sister with Down syndrome. So that was kind of bad, but I've been doing good with my depression medicine, my anxiety. I've been working with that good. I got a lot of people who support me and been showing support. They've been seeing the change. And this was, you know, like, not to diminish it or nothing like that. It was a decision. Like, it ain't even
Well,
nothing.
what led to the decision?
I don't know. Like, bad energy came around me, and I was just being social, and, you know, I was wrapping up feeling like I was wrapping up my probation, and I just was, like, lazy with it and just, you know what I'm saying, like, forgot really what was going on with that whole scene. So, you know, I just, just was being social with it, and it was just stupid. Like, it was a bad experience anyway, like, and it's not even on my radar to be doing something like that. Like, my life is going good. I actually got a movie that I only need 15 minutes of more footage left to finish a movie that I was supposed to be dropping this summer. And then I had the job, like, $20 an hour for me, like, without
Working where?
I had Evercare. Like, a guy came and approached me about when I was helping my mother. And he said, you know, you get paid for that. And I said, no. So I went up on Pearl Road. They did the background, and he was like, yeah, you can get it. So 9 to 2, that's what I was doing, Monday through Friday. And I'm like $20 an hour, like, you know, for y'all, it probably ain't nothing, but for me, and you know what I'm saying, my history on background and stuff, like, it was everything for me, like, and I was moving forward. My depression was doing good. I was, you know, I still don't go around people all like that, you know what I'm saying, that much, but I'm social. You know, I laugh and play, like, you know, the family lost, you know, my sister, and while I was in here, I missed my birthday, my son's birthday, which I was catching for like a year and a half straight. Like, I ain't been in here in a while. Like, I've been content and happy with the life I had. Like, I just made a stupid mistake. It's stupider every day. I sit in here and be like, I cannot believe I ever let bad energy come into my life, because I've been positive energy, and I've been hoping that I've been showing improvement. Everybody around me been seeing like, hey, it's improvement. You've been doing better. Like, you know, they
You
believe
still going
in me
to
now.
Signature?
Yeah. Oh, so I even if I was off probation, I'm still with Signature. They do my medicines. They do my mental
What
health.
medicines you taking?
I take trazodone. I take Lipitor. I got diabetes. I got high blood pressure. I got depression, and I have anxiety, and I got
Okay.
PTSD. So
What-
I take a lot of stuff.
Okay.
I take a lot of stuff.
Take it every day?
Yeah, I keep up on that, and it's been working. Like, Signature is real good. I have zero problem with Signature. I have zero. They come get you. They give you a an Uber. You know what I'm saying, there and back. So I had no problem. It's a nice facility. Like, I got nothing bad to say about Signature Health. So even if I wasn't on probation, I still would deal with them. Like, yeah, they help me out. Like, if I go down for depression or say something, like, they got counselors. Like, yeah, they cool. Like, I'm still with them on the regular. So, and I plan on having them still help me out through this, like, you know, just keep me moving forward. They keep me focused. And I just been focused on my own. Like, you know, you had me take the little, you know, trust the process. And that's what I've been doing 18 months. That's why you ain't seen me. Like, you know, just let bad energy just come in. Like, I just make stupid mistakes every now and then. They dwindling down. You know what I'm saying? Like, I'm not gonna be perfect. I know that much, but I'm working on it. I'm a work in progress, but it's been on the upside lately. Like, and stuff I've been going through, like my sister dying and stuff like that. I was right there. Like, I seen the lights go out in her eyes. Like,
When was that?
that was last year.
What month?
Actually, I think it was March. I think it was around my birthday.
All right. How often do you go to Signature?
Every time they need me, they call you to death. They call
Well,
a
how
lot.
often do you get the meds?
Oh, I get the meds all the time.
I mean, do you get a prescription for a certain period of time and then you have to renew
Yeah,
it?
yeah. They give you a prescription for them.
And how long does a prescription usually last for?
I think they 30 days. Like, they give you, you know, a bottle. So I think about like 30 days. Like, I still got some meds left right now. So maybe a little bit over. Some of them maybe a little bit over 30 days. Maybe a little bit. They left at least 30 days. They give me stuff to help me sleep, because, you know what I'm saying, my mind race all the time. And they give me stuff for the anxiety, because, like, when I'm around certain people sometimes, like, you know, still feel like the walls closing in. Like, I had an episode where I was in here, and they don't give you meds and stuff like that for in here.
How long you been in here now?
40 days.
Is that right, Dave, roughly?
41 days, Judge.
41.
Oh, yeah. And it's rough being in here, like, especially at my age. Like, my body ain't built for it no more. That's why I'm through with any violations whatsoever. Like, I'm done with it.
I'm always interested to know how mental health medication, which is meant to, in some cases, to create a balance, a chemical balance, why you think that mixing that with marijuana or meth is a positive?
I didn't think, you know what I'm saying? That's the whole problem. Like, I let bad energy just come in, a bad vibe. I'm usually good vibes, good energy, and that just wasn't even my scene. Like, I've been away from it so long. Like, I don't know. I just think I was just not thinking. It's just a bad decision. It was stupid. Like, it's not even my scene. Like, I've been gone so long from that whole scene anyway. Like,
where are you living?
I'm staying still at my mom's, 26300 Bardale. Stable location, like, probably one of the best streets in Euclid off 260th. I still help her out. We've been real close since my sister passed. Like, you know, that was kind of big for the whole family. And they just had to repass just recently, last month. So I missed that. That had me up a couple of days. That's probably why I had that episode with the anxiety thing. So. But I'm trying though. Like I'm gonna get it right if I can get a chance. Like I've been adding a lot of positive things. I got like 41 certificates of stuff that y'all ain't even asked for. Like I just got just trying to learn everything about me, about myself, about my surroundings, like about mental health, about diabetes, about law, about care service, everything I can get my hands on. Like I got like 41 of them. I gave to Dave. Like just a whole bunch of stuff. Like just trying to move forward. It's hard. I had a rough life, you know. Like, but I know that ain't no excuse for nothing. But I mean, moving forward, I can just tell you that it's gonna be positive energy still. Like if I did 18 months, I can do another whatever the courts tell me to do. Like even without the courts, I'm gonna do that. Like so many people didn't put trust in me and put faith in me. Like they ain't used to do that. Like now they kind of see like a difference. Like yeah, they kind of believe in me a little bit.
All right, Mr. Mulkey.
Yes, Your Honor, thank you. My client's been very concerned about his future in light of his violations. He realized it was a dumb mistake. My understanding is he thought he might be going to prison. He used these substances before he thought he was going to be going. If given the opportunity, I'm sure he would change his behavior then. He indicates to me that he will not be using drugs or substances in the future. He will comply with his community control requirements. We'd ask this court to extend his community control, Your Honor, not consider prison for him at this time. He understands some additional local incarceration might be part of his continued community control, and other more stringent conditions might be added as well, Your Honor. But he does take care of his mother, and he will follow the rules and regulations, and we would ask the court to take all of that into consideration. Thank you.
Okay, I'm going to continue you on community control. I'm going to serve 49 days in jail with credit for 41. And you're going to comply with the same terms essentially as to continue with signature and stop playing around with the drugs in all aspects of your life.
Yes, sir.
Mr. Tompkins, anything else?
No, Your Honor.
All right, that's it.
7 days, 41 days.
Your Honor has asked me to inquire to the court if it's possible to waive the additional jail time so that he can get back to his life, Judge.
Try to keep that job if I can. Like
Judge, he didn't have a job yet.
Okay,
You didn't have a job.
listen.
Let's just stop saying you got a job.
we were gonna pull pro roll it. I got the
You don't have a job.
Why didn't I work?
49.
Okie dokie, little dispute there about a job at the end. Good times. All right, let's go to Judge Stevens. Say good morning to him.
What are we doing today? That's you?
Yes.
This one's
Judge,
I'm sorry, you're charged, as you probably know, with a third-degree felony of says tampering with physical evidence, intentionally or knowingly concealing a firearm. And this is a third-degree felony, which carries with it up to 10 years in prison if convicted. And Mr. Turkis, your attorney, go ahead, thanks.
Judge, I think we just recently did all the discovery, and that was Ms. Robertson. This is her initial appearance. I've got to go over the case. The state has.
What are you asking for today?
Due to my last request, we probably need to reset it towards the end of May. So I would say a normal reset, but.
You're going military?
Yes, sir, for about a month. So 2 months.
You did the last week in May.
That's fine.
We try to move some stuff before you leave town?
Yes, sir. I'm working on everything. I'm not gonna just leave.
Sounds like you were about to.
I'm trying to.
You kind of cried into this.
You called me.
I get it resetting that. Thank you. Christopher Stelly.
Then we need to tap for it.
Stelly, 2 cases. Balancing in the movement here. Christopher
Three cases, Judge.
Stelly, or goes to the next page.
Yes, sir. This one does.
3 cases called on Christopher Stelly. Cause number 251642, evading arrest or detention with a motor vehicle. 25 CR 1643, state jail felony of theft of a firearm. And finally, 25 CR 26 CR 31, a newer case, state jail felony of unauthorized use of a motor vehicle. So we've got 2 state jail felonies up to 2 years in the state jail in each of those cases, and a 3rd-degree felony up to 10 years in prison for that one. 14 years collectively. The defendant is looking at. No answer in the courtroom on Christopher Stelly. I asked the bailiff to call into the hall for Christopher Stelly, please.
Judge, he may not be present. I'm looking at
In custody?
I'm looking at a federal indictment on this gentleman.
Oh, wow.
It is 18 USC 922 G1.
That's a firearm.
Yes, sir.
I've prosecuted 100 of those as a U.S. attorney.
That's why I read it out, Judge.
It's actually 922 subpart G.
Yes, sir.
No answer?
There's no response.
No response according to the bailiff's call outside. No response. The name being called here in the courtroom. Defendant has failed to appear. We're going to make some tentative findings based upon whether he is in custody or not. And what are his bonds on each? If he's in custody, he's unable to be here, and that purges him with any punishment for not being present when he's supposed to be. But if he's not in custody, then his bonds are revoked in each of these 3 cases.
So Judge, on the first 2 cases, the bonds are $15,000 each. And on the 3rd case, it's $8,000.
Okay, bonds are doubled in 1642 and 1643 from $15,000 to $30,000, and then 2631. You said it's 8,000.
8,000.
It's doubled to $16,000. Plus, the defendant must have a GPS device, and he is on confinement except for purposes of leaving to see his lawyer in the most direct route possible, to come to court in the most direct possible, to get food or medical care in the most direct possible, and he must also inform his bondsman of his travels before he can travel. John West, thanks, Brent. Jose Rodriguez. Sure. Jose Rodriguez, please. You Jose Rodriguez?
Yes, sir.
You were here with Mr. West, your attorney and the state's attorney. I don't have to tell you, this is a serious offense. You're charged with a state jail felony of solicitation of prostitution, which carries with it up to 2 years in the state jail. You know, it's illegal. Don't do that.
Yes, sir.
And you don't know what is happening in those situations when it's advertised. Could be law enforcement, like they got you on this one. But nonetheless, do the right thing. So the honest thing, the moral thing. You stay out of trouble. Now, Mr. West is here. What do you want to do today?
Well, this is the initial. We get some.
It certainly is.
We can get about 4 weeks to go over discovery.
Get a resetting. 4 weeks. He's going to review this with you and see what direction this is going to head in. Kalaya Martin.
All right, friends, let's go back to Michigan. Judge Simpson.
either in the Michigan court rules or the cases decided thereunder to the extent conflict does exist, give waivers, the court will consent to hear the matter. Is this the first one in Zoom?
Yes.
Court does call the case of the People versus Carla Bristow.
Your Honor, Raymond Cook, people.
Bristow?
Yes.
Oh, there she is. All right. Ma'am, you are before the court on a misdemeanor citation that alleges that on or about October 12th, 2025, at the location at 3160 Laurel Road, that being the coal store, that you did commit the offense of retail fraud in the third degree. Do you understand the nature of that charge, ma'am?
Yes.
That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court cost. Fine could be increased to 3 times the value of the property taken. That's greater than $500. That would become the maximum fine. You understand that?
Yes.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes.
This is a public defender case.
Assistant Public Defender Natalie Tate with an on behalf of Ms. Bristow, we would waive any formal reading of the complaint. My client stands mute, and I would ask for an adjourned pretrial date to receive and review discovery, please.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea on her behalf. Pretrial in this matter will be set for 15th, 2026, 9 a.m. Raise your invite indicates. We'll set the defendant's bond at $5,000 personal recognizance bond, although under standard conditions, including no assaultive behavior or possession of any weapons, ammunition, or anything fashioned to be a weapon, order no alcohol, recreational marijuana, or any illegal drugs. I will also order, ma'am, that you are not to go to any coal store in the state of Michigan. You understand that?
Mm-hmm.
Is that a yes?
Yes.
Anything further?
Nothing further, Your Honor. Thank you.
Thank you. Thank you, ma'am.
Thank you. I'm allowed to leave now?
Yes.
Cool.
Court does call the case. People versus Leandra Hardesty.
Good morning, Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Dan Garrett on behalf of Ms. Hardesty stepping forward. State your name, Leandra.
Leandra Hardesty. Oh, sorry.
Your Honor, for arraignment purposes, we'll waive. Stand mute, please.
Been arraigned.
Oh, she has.
Yeah.
Well, even better. I take all that back.
Very efficient.
Your Honor, Mr. Cook and I have had some discussions. We're asking for an adjourned pretrial for Ms. Hardesty to do some things behind the scenes. So if Your Honor would give us 4 or 5 weeks to get those things done. Yes, maybe 4 weeks.
Anytime.
June 3rd?
That seems like
That's like 8 weeks. 6. And like 4. That's it, right?
That's the perfect file. Yeah.
It's okay.
We thought you had a vacation. And then that wasn't likely.
Apparently, I'm taking a month off. I don't know. May 6th, 2026, 9 a.m. Continue thinking. What was? Okay, all right. We'll talk later. Court does call the case of the People versus Joshua Aurora.
Morning, Your Honor, Raymond Cook for the people.
Good morning, Judge Lawrence Margolis with Mr. Wara. Josh, please unmute yourself and state your name.
Joshua Wara.
How you doing, Mr. Wara?
Good, and you, Judge?
I think I'm doing okay. All right, where are we on this case?
So this is, I think, set for a competency hearing today. He was found competent. Mr. Cook and I are in discussions for a global resolution. Josh has several cases in this county, and we're hoping to get them all resolved. We're asking for 2 to...
I don't have... Do you have me set for a comp hearing? I think it's set as a pretrial. I think the comp came in another case because I don't even have I don't have a report.
Okay, okay. We'd ask for a short adjournment. We're gonna try to wrap everything up. Josh is doing well. He did two short hot, one short.
Will April 15th work? Or you need something like in, I don't know what month she's giving me, like August? No, I'm kidding.
April 15th, I'm actually leaving town to go visit my daughter in Spain. If anything, 2 weeks after that would be wonderful. Or, yeah.
May 6th. Will May 6th work? Apparently that's the day.
It will for me.
All right. May 6th, 2026, 9 a.m.
Thank you, Judge.
All right, Mr. Warren, take care of yourself, fellow.
Thank you, Judge.
Thanks, Josh. We'll talk. Bye.
Court does call the case of the people versus Paul Wilson.
You're Raymond Cook for the people. Joe Simon on behalf of Dustin, who's making his way to the podium. And state your name, Paul.
Good morning, Your Honor.
Morning.
Paul Wasson.
We reached a resolution.
I haven't said anything.
Honestly, I was waiting for,
I said to myself, there's Simon. I'm not going to say anything bad.
I almost cautioned my client. I forgot that my height would be referenced today, or lack thereof would be referenced.
Your lack of height?
Yeah.
How much different? Or you, we painted you blue, you would have looked like a Smurf. But
Okay.
I don't even know why I went there. But
I don't know. It's crazy. Anyway, you have a plea sheet in front of you, Your Honor. I think we've reached.
I do. Plea sheet indicates that the defendant is going to be pleading no contest to the charge of assault and or assault battery, 93-day offense upon his successful plea. That's the stated count.
Yes.
He'll be pleading to the stated count. There's a sentence agreement. Prosecutors deferred with no upfront jail. That's the court's full understanding of the agreement.
That's correct, Your Honor. It is, Your Honor.
May I have him sworn?
Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Good morning, Your Honor. Paul Wasson.
Sir, it is this court's understanding that you're going to plead no contest to the charge of assault and or assault and battery. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. Do you understand that, sir?
Yes, Your Honor.
All right. Do you understand what a no contest is?
Yes, Your Honor.
All right. Two things about it. I have to make sure that you understand. It first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that? All right. Basis for the no contest plea.
Potential of civil liability.
Sir, to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you will not have a trial of any kind. Signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up, or pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
Doing this voluntarily and of your own free will?
Yes, Your Honor.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 2521378. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. And that's, sir.
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people? None.
And have I complied with the court rule?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
April 29th at 12 noon.
April 29th, 2026, noon.
What's wrong with that? Okay.
Bond with its conditions will continue.
Thank you, Your Honor.
Thank you. Sir, you're welcome, sir. Make sure to stop down at probation. They're on the left-hand side.
Me with your son. Thank you.
Nina, thank you for your $20 donation over at courtroomfiles.com. Very much appreciate that. Thank you so much.
Mr. Chris Eastoe, who is the attorney of record for Mr. Snyder case. State your name.
Morning, Your Honor. Merrill, Snyder case. Don't have any problem with Mr. Simon's death.
No, Your Honor.
All right. As to the arraignment,
Waive formal reading, stand mused.
and then waive formal readings, the court will enter a not guilty plea.
Regarding the pretrial, Your Honor, Mr. Eastoe spoke with Mr. Cook. He's requesting a lengthy adjournment so that my client can get his Mr. Eastoe's client can get his status hopefully remedied by the time we return to court. That June date that I heard announced earlier, I think would work.
Wow. June.
Well, I thought I heard a date in June. I'm sorry. But
That was kind of an error.
whatever the court deems, Your Honor.
How much time is he gonna need to
Come on,
do it?
Yeah, I'm done. That's 6 months. What do you think? Well, I mean, will it take all of that? 45. 45 days, he's saying it would probably take.
What was that date you gave us wages for June what? June 3rd, 2026. 9 a.m. Bond is set at 5,000 PR. Standard condition, including no assault, or possession of weapons. Thank you.
Thank you, Your Honor.
Thank you, Your Honor. You're welcome.
All right, wait for me outside, please.
Court calls case People versus Adriana Banks.
Our Assistant Public Defender Constable on behalf of the who's present by Zoom. Ms. Banks, can you state your full name for the record, please?
Ariana Banks.
You turn on your camera, please.
Oh, yes, sorry. Is it on? I can't see.
Got it. No, we can see you. Hello.
Okay. Hi.
There is the time for the pretrial in this matter. We're going to be requesting an adjournment. There is an offer. Need some time to finalize that offer. Hopefully, solutions. So that's for about 2 weeks.
Pretrial in this matter will be adjourned April 15, 2026, 9 a.m. Bond will continue.
You
All
said
right, thank you,
April
Ms.
15th?
Yes, ma'am.
Okay, thank you.
Thank you. Court calls case of the People versus Carlton Cross.
Raymond Cook for the people. Assistant Public Defender Constable Lacey on behalf of Carlton Cross.
Not checked in.
As I understand it, my client is currently in treatment. We did send them over the Zoom.
Hello.
Hello. My name is Carlton Cross.
He's here. Thank you.
You're welcome.
We're going to be requesting an adjournment to track some other cases. My client has to be for a date past the 7th of April. My client has a hearing with Judge Conkey at that time.
He's what?
Just track what's going on with his felony cases. So we just asked for an adjournment for past April 7th.
I had a sobriety court. I thought they were trying to get him into sobriety court.
That's correct.
Trying to get into felony sobriety court or have this come along, or what are we doing?
Information I have is he had the hearing on April 7th with Judge Conkey, and I believe that
I'll adjourn it to April 15, 2026, 9 a.m. All right, sir.
All right. Thank you, Judge Simpson.
Thank you, sir.
Yep.
there you are.
Court calls case People versus Otis Elliott.
The Public Defender Constable Otis Elliott.
Sir, can you state your name?
Otis Elliott, sir.
Thank you. What are we doing?
We're requesting an adjournment to get some possible mitigating information.
What's my date after? May 6th.
Yes, sir.
Sure.
Very sure.
During the matter, May 6th, 2020, 9 a.m. bound continues. Oh, I didn't know you were there. I couldn't see you. I didn't know you. I felt unsafe. For another brief moment, I felt unsafe. It was on your hands to do so. Court calls the case People versus Javon Foster.
Your Honor, Raymond Cookie People. Public Defender Costin will base on behalf of Von Foster.
Hello?
Hello? Can you hear me?
Yep, we can hear you.
I'm sorry.
See you. We're
Okay.
good. What's your name?
Javon Foster.
Thank you. What are we doing?
Your Honor, we're requesting a hearing for good
Of course
conduct.
you are.
Foster,
Why? Go ahead.
we haven't been able to contact Mr. Foster, so
Right here.
I would like him to contact the Public Defender's Office and give us some good contact information. Mr. Foster, can you take down this phone number and please call them and update your contact?
Yeah,
info?
I got it's all of my stuff is still the same. My phone was just off. I just paid my phone bill last night. I'm
You need
sorry.
to call them, make sure that they have the information, okay? You
Okay.
got something to write down? A phone number?
I got all the information. My phone was just off. I just had to pay my phone bill.
Oh.
Understood. Your Honor,
Yeah,
we're
I
requesting-
literally just paid it last night. I'm sorry.
You paid it last night?
Yes, sir.
So it's on?
Yes, sir.
All right. April 15th. I'm good.
Thank you.
Bond continued. Thank you, sir.
Thank you.
All right, friends, let's change it up. Let's stay in Michigan, but we will go to St. Joseph County. Say good morning to Judge Middleton.
Mr. Barnett will be with you in a few minutes. Good morning. Are you Devon Allen Martin?
Yes.
This is file number 251308 FD. This started out in the original complaint as a felony. FD is a felony designation. Charged with operating with a high blood alcohol level, operating with an incapacitating injury. Let's look at the original charging document. Thank you. All right, the original complaint alleged that on July 6th of 2025, in this case, which is 251308 FD, People versus Devon Martin, the defendant was charged with operating while intoxicated, causing a serious injury, operating with a high blood alcohol level, and reckless driving. I don't believe there was an affidavit that accompanied it. The felony charges were dismissed and the drinking driving charge was dismissed. And the defendant ended up entering a plea to reckless driving. Reckless driving is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It does carry a suspension of sometimes 60 days, I think, and 6 points. So the felony charge of operating with an incapacitating injury was dismissed, and the operating while intoxicated was dismissed.
Your Honor,
Yes.
he actually pled guilty to operating with BAC, high BAC.
All right. Well, that's what I show here, I guess. Let me look at it. Thank you, Priscilla. So the settlement Thank you. Resolve the, I'm looking for the judgment. Resolve the case with a conviction, but the restitution was not negotiated as a part of the plea agreement. The defendant was sentenced on the 8th. Let me look for the judgment. I had all this earlier this morning.
I was sentenced on the 5th of January.
All right, the 5th, I guess it was.
Just emailed you the judgment. slip.
I've got it in here. I had looked at it earlier this morning. If I could find it. Nothing's in order. It's just all willy-nilly. At any rate, we did not have the restitution information at that time, and the issue had not been resolved, so I reserved on the issue of restitution. A few days later, on February 12th, we got the request for restitution. So the sentence had been completed. I reserved on restitution. Another month passed before we got the amended request for restitution, asking for $4,097.42. A floor jack, jumper cables, prescription sunglasses, loss of PTO hours, $2,710.72. Work done to make AC and car work shortly before the accident. Mr. Gibson objects to paying for a repair that preceded the accident and the tires that the victim did not get the full benefit of. So I'm not sure how that shakes out, but the request was for $4,097.42. If I'd had this information at the time of the sentence, I would have dealt with it then, or hopefully it would have maybe been negotiated as part of the plea, but we didn't have that. So the defendant objects. Prosecutor is now requesting restitution of $4,097.42. And I can't just wave my magic wand and make that happen, so we set it for a hearing. Angelique Campfield is here on behalf of the prosecutor. It looks like we may also have additional witnesses. Ms. Campfield, what's the position of the state here?
Well, Your Honor, the position of the state is that the testimony will provide the court evidence that even though there was some insurance recovery for the vehicle, it was a total loss. The vehicle needed to be replaced. And as a result of that, some of the repairs to the vehicle that were just prior to, inclusive of replacing and re-energizing an air conditioning system, as well as placing new tires on the vehicle, were not fully realized because the vehicle was then totaled. And as the court is aware, insurance companies often do not pay the entire value of a vehicle when they total it. They pay what they think is appropriate. And in this particular situation, I believe it would be covered under In Re McAvoy 267 Mishap 55 at pages 77 through 88.
Okay, slow down.
The restitution is not just.
All
the
right, well,
amount of
give me
what
the
the insurance
citation. Give me
company-
the citation again.
I'm sorry, 267 Mishap, page 55. And then it's pages 77 through 78, a 2005 case. that said it's not appropriate to order just what the insurance company would have compensated them for the damaged property, but rather the actual loss that was sustained by replacement value. And obviously, if you're only paid $3,000 for a vehicle and you would like to replace it with another Prius or another operative vehicle, in today's market, that is not going to suffice.
Well, this is a subject we teach at sentencing in new judge school. This is an interesting question in that they're asking for pre-existing expenditures. It isn't automatically, the restitution is what the insurance will pay for the car. The hypothetical example we give is somebody's mother has a Mercury Marquis that's in really mint shape. She drives it back and forth to church every Sunday, and it's a 1997. It's worth a lot of money to her. It's ruined. The insurance company pays $1,500 for it, and to replace it would be $7,000 to $10,000. It's a question that comes up all over the state all the time. In this case, I don't know what the vehicle was, how much it was paid for. Now, some of the things are easy to determine. Things that were lost that were not recovered. The jack, jumper cables, prescription sunglasses. I never had anybody ask for the cost of a tire iron before. Work done to make the car before the accident, $559.59 and $4,000 or $424. So there's a lot of money that she's asking for something that presumably would have been part of the settlement on the car. $559.59 plus $424.84 is $984.43 for tires and AC. I didn't see that one coming. The other one is PTO hours, 2007-10.
Your Honor, I can tell you that the testimony regarding the PTO hours will be the victim's father. It's my understanding that he had to cash out his PTO hours in order to have enough money, along with adding in the insurance recovery, in order to purchase another vehicle for the victim to have to get back and forth to work, the grocery store, and to do her daily living. They just did not have those funds available without him doing so. So that will, of course, be a decision of the court with respect to that. I know the victims is absolutely recoverable. There will be testimony from her about the hours.
Victims are. I'm not sure if her fathers are.
There'll be testimony from her loss of income as well as how it affected her work.
All right. Well, let's get started. This is going to take us a while here.
We didn't, I guess I would say that I don't have any information on any of the injuries that were sustained, because I guess that's what I see the request for restitution, but we never got any information about the cause, like in a sense, what injury was suffered from the accident that's made it where the person couldn't work, I guess.
The medical records were all provided in the discovery of the underlying case, Your Honor. Mr. Gibson has had those for quite some time. The victim was taken to the hospital.
Yes. There's no hospital costs or anything in here.
Correct.
All right.
It's my understanding those were covered by medical and or vehicle insurance.
I guess I apologize. We do have medical records. I guess what I'm saying is that I didn't know what the.
Well, I'm just
injury was.
frustrated. I wish this had been negotiated as part of the plea agreement. He got a sweet benefit of having the matter reduced from a felony to a misdemeanor. And it could have been conditioned on agreeing upon the restitution amount. So we have a half an hour scheduled for about a 3-hour hearing. And so we also have Mr. George. Is that the only one you have this morning? Let's table this for a moment. Let's finish Mr. George's sentence and then we'll come back to this. Yeah. Or I'll shut the record off. The live stream is on. I'll caution everyone.
Okie dokie, we'll come back when they come back. In the meantime, let's go back to Judge O'Donnell.
Are you waiving that right?
Yes, Judge.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, Judge.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, Judge.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, Judge.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, Judge.
Are you waiving that right?
Yes, Judge.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, Judge.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, Judge.
Do you have any questions about any of these rights?
No, sir. No, Judge.
Do you still want to plead guilty to this charge?
Yes, Judge.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes, Judge.
Do you understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control?
Yes, Judge.
The attempted failure to comply with the order or signal of a police officer is a felony 5. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, Judge.
Is there, does that driver's license suspension apply?
Not when it's an attempted, Your Honor.
All right. Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority?
Yes, Judge.
If you are placed on post-release control and violate any conditions, the parole authority could return you to prison for up to 6 months. Do you understand that?
Yes, Judge.
If that violation is a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, Judge.
And if that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, Judge.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes, Judge.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 12 months. Do you understand that?
Yes, Judge.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, Judge.
Has anybody promised you what I will sentence you to in this case?
No, Judge.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, Judge.
Have you had enough time to talk with Mr. Wolkanowitz before pleading guilty today?
Yes, Judge.
Has he discussed everything about your case and answered all of your questions?
Yes, Judge.
Are you satisfied with the advice he has given you?
I am, Judge.
Have you been threatened or coerced in any way to plead guilty today?
No, Judge.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, Judge.
Do you have any questions at this point?
No, Judge.
All right, Ms. Cutts, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on December 16th of 2025, Mentor Police Department was investigating a hit skip report from the Ford dealership located in Mentor Lake County, Ohio, involving a white Hyundai Tucson driven by Amy Funk. Her car was struck by what was later turned to be a blue Dodge Ram that came back to the defendant, Darius Johnson. A traffic stop was conducted State Road 2 eastbound east of Heisley Road, where the driver and only occupant was in fact the defendant, Darius Johnson. While speaking with police at the traffic stop, he was attempting to get a copy of his insurance card. The police went to look into other matters and to get him the report number and said they would be back while they were dealing with other issues. Defendant drove away from the traffic stop without being told he was free to leave. Defendant did later call the police and indicate that he was willing to pay for the damages. Video camera footage was able to be reviewed from the Ford dealership as well. All is occurring in Lake County, Ohio, and that would have been the state's evidence.
All right, Mr. Welkanowitz, do you have anything to add to those facts?
Not at this time, Your Honor.
All right, Mr. Johnson, did you hear what Ms. Cutts said, that the facts would show if this case went to a trial?
Yes, Judge.
Are those facts true?
Yes, Judge.
What is your plea to the attempted failure to comply with the order or signal of a police officer, a felony 5?
Guilty, Judge.
All right, Mr. Welkanowitz?
This is the guilty plea that went over, so just date it there and then sign there.
Your Honor, proceed the written plea of guilty and judgment entry. I witness the defendant sign the document on the court. His counsel signed it and I signed it.
All right, Mr. Johnson, is this your signature on the written plea of guilty?
Yes, Judge.
Did you sign it voluntarily?
Yes, Judge.
Do you want me to accept your written plea of guilty?
Yes, Judge.
I'll accept the written plea. I will accept the written plea of guilty. Defendant was present with counsel, advised of all of his rights in a knowing, intelligent, and voluntary waiver. He understands the nature of the charge and consequence of his guilty plea and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept the plea of guilty and find him guilty of the attempted failure to comply, a felony 5. I'll refer this for a pre-sentence report and victim impact statement. Sentencing will be May 13 at 2 o'clock. Bond is continued at $5,000, cash or surety or 10%. You are permitted to reside in Cuyahoga if that's where you reside, and you are permitted to travel. Counsel tells me that you got a trip to Ocean City, New Jersey. You are permitted to travel for that purpose. Anything further, Ms. Cutts?
No, thank you, Your Honor.
Mr. Welkanowitz? Anything
No,
else?
Your Honor, thank you.
All right, we're adjourned.
Counsel, you got the
Okie dokie, friends. Let's go back to Judge Middleton. He's returned to the bench.
Which case are you folks here on? All right. All right, let's pick up here with People versus Samuel Robert Barnett. File number is 26195SM. Mr. Barnett was charged with domestic violence or domestic assault. He entered a plea to that matter, and the matter was set for sentencing for today. The prosecutor did offer the deferred option for the sentence. I wanted to get more information, get input from the complaining witness, and so the matter was set for today. In the meantime, an allegation came up regarding a bond violation in that he made contact with the complainant on March 5th in violation of the no contact provision of the bond. The defendant is here with his lawyer, Mr. Timothy George. Also, Josh Robert and Abigail Stoll are here for the prosecutor. Are we going to continue with the original plea with the sentence with the original plea with the deferral?
Yes, Your Honor.
And then regarding the bond violation, what's our status with that?
We would dismiss the bond violation at this time. We feel like the defendant being placed on that kind of intensive DV probation that the court typically orders in one of these cases will safeguard the victim, and that no contact order will be in place. Then speaking with Mr. George, it sounds like his client agrees wholeheartedly that no contact should be in place.
All right. Mr. George, what would you like me to know regarding the sentence?
Well, and I know we started last week a little bit, Your Honor, but I think the court can get a sense of there's a lot of animosity between the two parties in this case. I know that the court's position and your admonishment of my client last week, I think really had a significant effect on him. He understands how seriously this court is when it gives orders, and it's going to be incumbent on my client moving forward, if the court were to put him on a probation, to follow those orders. We would stipulate that the no contact order stay in place. Based on some of the things that have happened over the past month or so, I think that would be appropriate. It would also give, the victim some ease regarding any type of communication with my client going forward. And my client just needs to focus on himself and his family and his treatment and make sure that something like this doesn't happen again. So, we would ask the court to follow the terms of the plea agreement. I don't believe my client has any type of criminal history that would bar him from the deferral probation. I believe he could use it. He's still very young. There's very young kids that are involved in this case. So my client's going to need to find some tools to cope with some of the issues that he's having. And I think this probation would offer him. So we'd ask the court to follow the plea agreement and put him on the domestic violence deferral probation. Thank you.
All right. Mr. O'Bear, what's your position?
We'd ask the court to follow the plea agreement, place him on that probation, order the no contact, order some type of DV or anchor management as part of that probation, so that this is a situation that does not repeat itself.
All right. One of the things I adjourned this for is I want to hear from Angelica Berg.
And she's here. She can address the court if you'd like.
Right. And to further complicate things, the parties don't have any contact, but she's pregnant. And he's married to someone else. And she's got his child. And there's a lot of animosity. Ms. Burke, would you come forward if you wish to? You don't have to if you don't want to, but I'd like to.
At the podium, or she can take my seat.
Why don't you take your spot? thank you for being here. You're Angelica Burke?
Yeah.
All right, this all happened on a very bad day in February. Dan Samuel got arrested. It was all at the Tower Motel, I think, wasn't it? Broke tobacco and dumped beer and, anyway, what would you like me to know?
So honestly, I don't know. I don't know what to say.
Well, let me ask a couple questions. You're getting prenatal care for your baby? Is that yes?
Yeah.
Where's your doctor?
Kalamazoo, Michigan,
Okay, what's your due date?
August 24th.
And so at this point, you're going through all your prenatal stuff by at least without Samuel being involved in it. Is that true?
Yes.
All right, and he's gonna be the father of this child, which is gonna be born in August. And that's rough all the way around, not to mention for the child. But at this point, you don't wish to have any contact with him, is that true?
Correct.
One thing I wasn't clear completely on, was he intoxicated when this happened?
Mm-hmm.
Tell me about that.
He got off work, he was gone all day. He even told me he was drinking. And I had a feeling that he was gonna come home drunk, and that's exactly what happened. He come home drunk.
Well, he also drove home, didn't he?
Yeah.
Yeah, so he drove home drunk, correct?
Yes.
All right, go ahead.
He had also was driving in Constantine, people have seen him over there.
All right, the problem with that is his PBT was 0.00 when the state police pulled him over. So I'm not sure what that's about, but that's why there was no drunk driving component to this. But go ahead.
I'm being honest, I think it might have not been alcohol. I mean, I know it was alcohol, but I think he's on drugs.
Okay. What's your plan moving forward? Do you have other kids?
I just have my 9-month-old and then this one, and then I'm working on, they found me a place to go, and
Now, he's also the father of the 9-month-old?
yes.
All right. So this is a rough gig. You're gonna have 2 kids and he's the father and he's married to somebody else. And we got a no contact provision. All right. What the prosecutor is proposing is that I put him on the most intensive domestic violence probation that we have. He will do the domestic violence treatment program. He will not be allowed to drink any alcohol or use any drugs. I will test his blood or urine periodically to make sure he isn't using drugs or alcohol. And he doesn't have any contact with you until I say so. If you wish to lift the no contact provision, I can do that. If he successfully completes all that, the charge would be set aside as a public record of conviction. So he contacted you in violation of the bond. The prosecutor is willing to drop that. If he does it again, I'm going to put him in jail. I've got up to 93 days to work with. So no drugs, no alcohol, testing, no assaultive behavior, no contact with you. And I'm going to send him to the domestic violence treatment program. That's what the prosecutor is requesting. So that's where we're headed. So you stay right where you are. Mr. Barnett, I usually give the defendant the last word. Probably the less you say here, the better. But is there anything you wish to tell me?
No, Your Honor.
All right, I'm glad everybody is here. This is a contentious situation and is not easily resolved. Because to some extent, you guys are stuck with each other for the next 18 years. But I don't want you using any drugs. I don't want you using any alcohol. I don't want any assaulty behavior. I'm doing a 24-month probation. You did 1 day in jail. I'm gonna do 61 days in jail, credit 1. Of the 61 days, 60 are deferred. So I got at least 60 days hanging over your head, and I've got 93 days that I can use. To make the fine 0, you got enough other stuff to pay. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee, $960 probation oversight fee. If you do this in 1 year, the statute says if you do a good job on probation, you're entitled to reduced half. So if you can do it within 1 year, it'll save you $480 and you have to pay for the class. I'm doing the full DV class. No assault or threatening behavior, drugs and alcohol testing as directed. No contact. You can contact the probation department at some point if you wish to have us lift the no contact provision. But while he's on this probation, he's not to have any contact with you. No telephone calls, no texts, no emails, no Facebook, nothing. Which is rough because you're about to have a child and you have another child. You're very irresponsible in that regard, but you got a 9-month-old and another one on the way, and you're married to somebody else. And ultimately, you're going to get support issues. And this isn't great. Anyway, if I can get you through the domestic violence class and keep you drug and alcohol free for a year, maybe we're off to a good start. I'm assuming you don't receive any child support or financial assistance from him.
Not yet.
All right, this is not great. We'll do the best we can. Mr. Barnett, I got 60 days hanging over your head. The prosecutor agreed to dismiss the 1 bond violation, knowing I got 60 days to hang over your head. And it won't take much for me to impose it. So I want you to comply with the terms of your bond and of your probation. And if you complete the probation, the charge will be made non-public.
Okay.
Are you working somewhere?
I'm getting ready to, I have an interview today at Elwood after I leave here.
All right, I want you to take this. Tim, I'll have you take it.
Yes, sir.
We're gonna get you plugged into probation. In fact, why don't you guys leave first? I don't want you to have a confrontation with him out in the hallway or the parking lot. So you guys are good to go. If you have questions or concerns, call the prosecutor's office or the probation department and we'll address those.
Thank you, Your Honor.
Thank you. All right, Mr. Barnett, I want you to hold up your end of the deal. And we'll see what we got. Thank you. All right, thank you for your patience. I'll stop the record and then we'll get back into our restitution hearing.
Seems like the main thing is that bottom issue, which is kind of like your like a legal argument.
To just stick to the stuff that was in the car and just focus on the other.
Maybe I should see a PTO on it. If you take away the PTO, that it would he agree to everything else, but it seems like he might have an objection to. Well, that's the old one, right? That doesn't have the thing about the tires, she attached a receipt for those tires and they were purchased like in December. So she would have had those tires for 7 months before, 7 or 8 months, but I guess.
I mean, and that's gonna be up to the court. I mean, I can only present those things and see what he determines. Arguably, but these items were in the vehicle and not recorded.
Could the insurance, if she got PIP benefits, can the insurance companies sue him? Can they come after him for those benefits?
I'm not gonna make her do that when she can recover it criminally.
Right,
You know
but
what I
I'm
mean?
saying.
It's just the easiest route is to have it done. I mean, this one, it's gonna be done. I mean, if he wants to just agree to the things that are in the car, I can just present testimony focusing on.
Okay, friends, we're a couple minutes in the Wayback Machine here with Judge Middleton, but I want to stay with him because that restitution hearing that was started before he walked away is getting continued. So I'm just going to bump us forward here a little bit. And then get that racked back up. How's this?
Your Honor, after some further conversation with counsel, it's my understanding that we'll be able to limit the testimony to matters in dispute, but at this time, the defendant would stipulate to restitution for the floor jack of $69.95, the jumper cables of $31.78, the prescription sunglasses for $273, and the tire iron for $27.54. So that's a total of $402.27. And then we'll have to present testimony as to the other expenses.
All right. Are you prepared to do that?
Of course.
Mr. Gibson, you agree, and Mr. Martin, you agree to restitution on those items?
Yes, Your Honor.
All right, and the defendant did indicate. All right, let's proceed.
And thank you, Your Honor. We'll call Ms. Kayla Shockley to the stand.
Please come forward if you would. Come right up here in the witness box. I'm sorry, we didn't give you very good instructions. Oh, wait a minute. Instruct people how to bring their witness from there to here, and we kind of got off track here. Would you please raise your right hand? You swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief?
I do.
All right, would you have a seat and state and spell your name for me?
I am Michaela Shockley. You said spell.
Go ahead, spell it.
It's spelled MICHAELASHOCKLEY.
Thank you. Good morning, Ms. Shockley. I'm going to take you and back to July 5th of 2025, ma'am. Do you recall that day?
I do.
In the evening time at approximately what would be 11:30-ish, were you driving your vehicle?
I was.
Where were you driving your vehicle?
I was driving home after work.
On what road, ma'am?
US 131.
And was that within St. Joseph County, ma'am?
It was.
And as you were driving home from work, did something unusual happen?
It did.
Were you involved in a motor vehicle accident?
I was.
What was the vehicle you were driving at that time?
A 2013 Model 4 Prius.
What was the color?
Navy blue.
Can you tell me what special things a Model 4 has in it that maybe some other Prius models do not?
It has a backup camera. It has a navigation system. And hands-free.
And hands braking, you said?
Hands-free mode.
Oh, hands-free, thank you. All right. And as you were driving home that night on July 5th of last year after the accident, was the vehicle operable?
It was not.
Would you recollect how it looked after the accident if you saw photographs of same?
I would.
May I approach, Your Honor?
Yes.
I'm going to show you People's Proposed Exhibit 1, and for the record, all the People's Exhibits have been shown to the defense. Do you recognize that photograph, ma'am?
I do.
Is that your vehicle?
It is.
Is that subsequent to the accident that you were involved in?
It is.
Is that the accident that the defendant was convicted for drunk driving for?
It is.
All right, and I'm going to show you People's Proposed Exhibit 2. First of all, Exhibit 1, can you tell me which portion of the vehicle that shows?
Yes. That is my trunk from where he impacted.
And Exhibit 2, do you recognize that, ma'am?
I do.
What is that a picture of?
That is the left-hand side, the driver's side of my car.
All right. Were you seat belted at the time of this accident?
I was.
And let me ask you, when you were subsequently removed from the vehicle, were you able to get out of the vehicle on your own?
No.
When you were removed by medical personnel, were you able to see the exterior of the vehicle?
No, because I was very dizzy from hitting my head.
All right. Did you subsequently see your vehicle as depicted in the conditions in proposed exhibits 1 and 2?
I did.
Okay. Do those accurately depict how it looked after the accident?
It does.
Okay, move for admission of exhibits 1 and 2, Your Honor.
Any objection?
No objection.
Right, 1 and 2 may be received.
May I ask you, Ms. Shockley, were your airbags deployed in the Prius when you were struck?
Yes.
Can you tell me if there was just one impact by the defendant or more than that?
It felt like 2.
Do you recall, and I know that you said you were busy, did you strike your head?
I did.
And did you have medical treatment after the accident?
I did.
What type of medical treatment did you have?
I had a CT scan due to the fact that I have a spinal fusion from a previous accident in 2018 that left me with missing intestines as well. And so I'm a priority CT scan for my spinal fusion if I'm involved in a serious accident. And I also received pain medication due to the severity of my sprained shoulder and the pain from my head.
Okay, let's go over your injuries. You said you had a sprained shoulder.
Yes.
Did you have to have?
Just a minute. These are all good arguments about why this matter should not have been reduced from a felony to a misdemeanor. But I'm trying to zero in on the restitution. These are compelling arguments. I think a jury would have enjoyed hearing all this. But they don't go to our money issue.
Your Honor, they're going to go to a request of this victim for 3 days of lost pay.
Okay.
So,
Well, you could just ask, did you lose, because of your medical treatment, did you lose 3 days of pay?
Certainly, Your Honor. You said a head injury and a shoulder injury, is that correct?
Yes.
Were you able to work immediately thereafter?
I was not. I had severe whiplash and could hardly move the next day after.
How many days were you off from work?
If you do not include my already 2 scheduled days off, I would have been off a total of 5 days.
Where do you work?
I work at Wagner's grocery store in Matawan. I am the night manager.
What is your rate of pay as the night manager at Wagner's at that time?
$14.73.
When you say that, is that $14.73 per hour?
Yes.
And on those 5 days, would you have worked an 8-hour shift each day, or do you work overtime as a manager?
I work an average of 2 hours of overtime a week.
All right, so for those 5 days and the overtime, would you have been approximately 42 hours?
Yes.
And that was lost due to the injuries from this accident? Now, with respect to that, your $14.73 is your normal hourly rate. Is there an additional compensation for the 2 hours of overtime?
Yes, it is time and a half.
Thank you. So that would have covered 2 hours and then the regular rate for 40 of those hours? Is that accurate? I'm sorry, is that yes?
Yes.
All right.
Sorry.
Because we're having you testify, sometimes although we're making a video of it, they'll need to transcribe it later. So we need verbal responses if you can recall.
Okay.
I appreciate that. Thank you. Did you have any items other than what have already been stipulated to within the vehicle that were not recovered or paid for by insurance?
I did.
What were those things?
I had a snow brush that was personal to myself. A couple items of clothing that were in the car as well, and some lip balm and other like pens and miscellaneous items.
Are you seeking compensation for those items?
I am not.
Okay. Now, was there an insurance claim made on this vehicle?
There was.
Was it registered in your name or someone else's?
It is registered in my father's name.
And his name, please?
Ralph Schibler.
And I'll have Mr. Schibler testify, but if you'll recall, prior to this accident, was there any maintenance that was done on the vehicle in close time to the accident in July of last year that was necessary to keep it operable and working well and safely?
At the beginning of June, we had the air conditioning redone due to the fact that it went out over the winter. And we had, I believe, December, we had the tires replaced.
Do you recollect about how many miles you would drive in a week on those replaced tires?
I can't do a large math in my head, unfortunately. I drive an average of 32 miles a day to work, and then 32 miles home.
All right, and you work about 5 days a week?
Yes.
You would have had some small errand miles on it for grocery store, things of that nature? Okay. Do you believe that at the time of the accident, the tires that had been replaced in December still had a decent tread on them, if you know?
From when the air conditioning was worked on, they told us that our tires were perfect.
Did you have to have any subsequent medical treatment for your whiplash and sprained shoulder or a cost of any pain medications that were not covered by any insurance?
No, I did not.
Thank you, Ms. Shockley. Nothing further.
So as far as your work, when you get paid, do they take out money toward taxes or other deductions?
They do.
So your after-tax earnings would be approximately 85% of what your earnings are, is that correct?
Yes.
Did you, after this accident, did you get in touch with your insurance company?
My father did.
Did you receive some type of insurance benefits as a result of the accident?
We did, yes.
Did you get what could be called, did you get compensation for lost wages through your insurance company?
No,
Do you know why you didn't get those?
I do not.
So was the car totaled?
It was.
And so did your father get, I guess you could say, a payout for the cost of the car or the value of the car?
No, it didn't get equivalent to the value of what the car was.
Did the insurance company did he get any benefits as a result of the accident then?
We got some restitution.
Was the, okay, I have no further questions.
Ms. Shockley, did the vehicle insurance cover the floor jack,
It did not.
the jumper cables?
It did not.
Did it cover the prescription sunglasses?
No,
Did it pay for the tire iron?
no, it did not.
And just to rehash this, did the insurance give any wage loss for those 5 days that you were out of work? Do you recall receiving any of that? Or is that a better question for your father?
Actually, I think I did, Dad. I did. I received some of 300.
Do you know if it's a reduced amount, such about like 83% or so?
The insurance company did not communicate that to us, whether or not.
No further questions, Your Honor.
Thank you, Ms. Shockley. I'm sorry I had to go through all this. You may step down.
Your Honor, I'll call Ralph Schindler to the stand.
Good afternoon, or good morning, Mr. Schindler.
Morning.
You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
All right. Why don't you have a seat? Spell your last name for us.
Schindler is spelled S-H-I, B as in boy, L-E-R.
Thank you.
Good morning, Mr. Schindler.
Morning.
I'm going to take you back to July 5th of 2025, sir. Your daughter was involved in a motor vehicle accident, is that correct?
Yes.
At the time, she was driving a 2013 Prius Model 4.
Yes.
Is that vehicle registered and owned by you?
Yes.
All right. Just prior to that accident on July 5th of 2025, have there been some reparations or maintenance done to keep the vehicle safe and operative?
Yes. The air conditioning had went out over the winter, and so it had to be overhauled and recharged. So
All right.
we had that done.
May I approach, Your Honor? Did you provide my office a receipt for that?
Yes, I did.
And would you recognize it if you saw it again?
Yes, I will.
I'm showing you People's Proposed Exhibit 5. Do you recognize that document, sir?
Yes, I do.
And is that the receipt for the air conditioning reparation that you were just speaking of?
Yes, it is.
And that was done at what date?
It was done on the exact date of 5/19.
All right, of 2025, sir?
Yes.
So just about a month and a half prior to the vehicle accident, is that?
Yep.
Right. And did the insurance company compensate you at all for having to have this air conditioning unit work done?
Nope.
Okay. Did you make a claim to insurance that included that?
I tried, but they denied it.
Okay.
And has this been changed in any other manner from when you provided it, other than the exhibit sticker being added?
Nope.
I'm going to move for admission of exhibit 5, Your Honor.
Any objection?
No objection.
Exhibit 5 may be received.
Thank you, Your Honor. I'm going to show you also your daughter, Ms. Shockley, had testified about some new tires on the vehicle about December of 24. So
Yes.
about 6 months or so prior to the
Yes.
accident fair. Did you pay for those tires, sir?
Yes, I did.
And did you have a receipt that you provided
Yes.
our office as well?
Yes.
Would you recognize that if you saw it? I'm going to show you people's proposed exhibit 4. Do you recognize that, sir?
Yes.
Does that contain the receipt for the tires that you put on the Prius prior to the accident?
Yes, it does.
And is it accurate but for the addition of the exhibit sticker?
Yes.
And what date were those purchased?
Those were purchased on my birthday, 12/5.
Well, happy late birthday, or early birthday for this year. All right, and has it been modified at all?
No.
All right, move for admission of exhibit 4, Your Honor.
Any objection? All right, number 4 is also admitted.
So, Mr. Schindler, when you went in for the air conditioning to be refurbished or repaired in May of 2025, did they take an overall look at the vehicle to ensure everything else was operative and safe?
Yes. They informed
Did
me.
that include an inspection of the tires?
Yes.
Were the tires in still a relatively pristine or unused condition?
Yes.
Let me ask you, when you purchased them in December of the prior year, were they new?
Yes.
Okay. So there had only been several thousand miles over those 6 months placed on that tire?
Correct.
Did the insurance company compensate you for the new tires that were lost during the accident?
Nope.
Let me ask you, sir, do you know what the approximate blue book value of the Prius was around the date of your daughter's accident?
It's depending on conditions between 14 and 15.9.
When all was said and done with the insurance, well, who's your insurance company?
At that time, it was Pioneer Mutual.
What type of insurance did you have on the vehicle?
Full coverage.
So comprehensive as well as PLPD?
No, that's not full coverage. Comprehensive and PLPD is different than full coverage. So you had full coverage on the vehicle.
Okay.
Good for you.
Thank you, Judge. Now, when you submitted the claim for your daughter Michaela's accident, did Pioneer pay you out on the vehicle?
Yes.
Did they choose to total the vehicle?
Yes.
What was the total payment that you received?
I believe it was 3,900.
When was that paid to you?
It was paid towards the end of July.
Now, there were some questions that we asked Ms. Shockley regarding wage loss reimbursement. Do you recollect any claim being made for her wage loss to the insurance company Pioneer?
I don't recall it, but I think she's right. I think they did give her like a $300 check or something like that.
Okay.
I think they covered like 2 days.
So of the 5 days that were lost, you believe insurance only covered 3 of them? And we'd already asked some of this to Ms. Shockley, but the items that are being agreed to by the defendant, the tire iron, the jack, things of that nature, did insurance give you any compensation towards those items?
No. They didn't cover any of the contents of the car.
All right. Now, obviously, $3,900 is a lot less than the blue book values you stated of $14,000 to $15,900, correct?
Yes.
Did you have to get another vehicle for Ms. Shockley to be able to drive to and from work and in her daily living?
Yes.
Do you recollect what vehicle you purchased to replace the Prius that was damaged by the defendant and totaled?
A 2013 Prius Model 2.
So the same year, It was still a Prius, but it was a Model 2.
Correct.
So you'd previously had a Model 4.
Right.
How is the Model 2 different?
No backup camera, no navigation system. It's just above the base model.
Okay. Does it have any hands-free operation?
It does have the hands-free, but it's a different type of hands-free than what's in the Model 4. A different brand.
So if I'm understanding your description correctly, you replaced the vehicle with something that was a lesser model than what she had been driving on the date of the accident.
With more miles on it.
Okay. Do you recollect what the miles were on the vehicle on the date of the accident?
To be honest, no, we don't. I had an oil change. I believe it was like 198,000.
Okay.
But I think it was just over 200 after, because that's when the oil change.
Okay. And then how much were on the new Prius Model 2 that you had to replace that vehicle with?
There's over 200,000. It's 201,000, I believe. That's what it was.
Okay. Now, did you have the money available to purchase this new vehicle? How much did it cost?
It costs, it was 6,500 is what I had to pay for it. Plus taxes and title and all that.
And you'd only received 3,900 from the insurance company, sir, is that correct?
Correct.
How did you make up for the difference?
I cashed in almost 3 years worth of vacation time.
Describe to me how that, first of all, for whom are you employed?
I'm employed by a company called Actilent. I'm a contractor, and they are contracted by Lexmark Corporation, which
All
is now
right.
Xerox.
And when you have PTO time, how much do you receive annually?
40 hours. Because I'm a contractor, I only get 40 hours.
Does that time roll over into the subsequent year if it's unutilized?
Yes, they will allow me to roll it over for 3 years.
Okay. Now, did your daughter, Miss Shockley, have the money to cover the difference between what insurance paid
No,
and the price of the new vehicle?
no.
Did you have any other manner by which you could accumulate money to pay for the new Prius?
No, I can't get a loan because I'm in a bankruptcy.
Oh, I understand. Okay. If I showed you a pay stub that indicated the hours that you had to cash in, would you recognize it?
Yes, I would.
I'm going to approach, if I may, with People's Proposed Exhibit 3. And Mr. Schibler, is that the pay stub that you provided to my office with those PTO hours cashed in?
Yes, it is.
What was the cost of those PTO hours that you had to utilize due to this accident?
The total came into $2,710.72.
Would you have lost that PTO money if you hadn't had to replace the vehicle for your daughter?
No,
Did you have to take any other time off from work after she was injured to assist her with daily living?
I did, but I didn't. I can work remote occasionally, so my boss just let me work remote while I was taking care of her.
How many days were you taking care of Michaela?
It was 2.
With respect to the vehicle insurance for medical coverage, did she have to go to the hospital?
Yeah, she went to the hospital, but the our deductible had been met for the year, so the insurance covered the 80%, and then the car insurance covered the rest.
So the family was not out any money for her medical care and coverage. Okay.
I mean, it would have cost for like the medications and that, but those are minimal.
You did not keep a track of the prescriptions or things?
No.
Okay. Is it fair to say that the items that you've turned in for restitution are the major ones and not the entirety of the loss that was
Yes.
suffered? You could have claimed for prescriptions, fair?
Yes.
You could have claimed for some of the other items lost in the car that your daughter mentioned, her clothing, her lip balm, a snow brush, things of that nature.
Yes.
And you both chose not to do that?
Correct.
So,
The jack that was in there is when I get a new car, the first thing I do is get rid of the scissors jack and put a 4-way tire iron and a floor jack in the back of the car because I have daughters and I don't want them out straight and trying to use a scissors jack.
all right. So in your opinion, the floor jack and things that you provided and that were in this vehicle and were lost are more able to be utilized by your daughters if they were to have a flat tire on the road?
Yep.
Okay.
Exactly.
So it's safer for them?
Mhm.
Now, with respect to this, then, you're asking for the lost wages of $2,710.72 for the PTO that you would not have had to cash in, but for needing that money in order to help your daughter replace the vehicle that was damaged.
Correct.
And it actually was your vehicle, fair?
Yes.
Registered and owned by yourself.
We share it.
Okay. Did the insurance company allow you to remove the tires off of the totaled vehicle?
No, and they were shredded. Pretty much. I mean, there was gashes and stuff in them, chunks of rubber.
Okay. You were able to go and see the vehicle after the accident?
Yes, I was.
Did you go over that at all with the insurance adjuster?
Yeah, we did. We went over everything.
So you saw the condition of the tires as you just described? Would you still have that PTO in your bank, Mr. Schibler, if this accident hadn't occurred and you needed to replace your vehicle?
Yes, because we were saving it up so that we could go on a vacation this summer.
And other than my adding the exhibits here on the back of that case stub, is it accurate as to the loss?
Yes, it's a direct download from my company website.
And thank you. Move for admission of exhibit 3.
No objection.
And exhibit 3 is admitted.
Further questions? Mr. Schibler? Thank you.
Mr. Gibson, you have any questions?
So, sir, you yourself did not suffer any type of physical injury from the car accident that your daughter was involved with, correct?
No, not any physical injuries, no.
Okay. Did you suffer any direct financial or emotional harm as a result of the crime?
Yeah, actually emotional. I mean, my daughter texted me from inside the car because they hadn't got her out yet, that she'd just been rented because the talk to text turned rear-ended into rented.
Did you suffer any direct financial loss as a result of the crime?
My vehicle.
Now, the insurance company, you said they paid you $3,900?
Yes.
Was there a lien against the vehicle?
No, there was not.
So how did you only get $3,900?
Because they couldn't read the odometer. That's what they told me they would give me.
Did you get in touch with an attorney or question that?
No. To be honest, I didn't have the time. I had to get another vehicle. And get
When
it on
did
the
you
road.
purchase the vehicle that was totaled?
2 years prior, I think.
So I guess I want to clarify. So you believe the vehicle was worth between 14 to 15.9.
Yes. And that is
You
based on my
issued, you had
search.
full coverage. You made a claim to your insurance company and they said they would only pay you $3,900 and you didn't question that. You just accepted
No,
it.
I did question it. It's just that it would have taken way longer to keep questioning than to do what we had to do to get a vehicle because we had to be able to get back and forth to work.
Was the air conditioner working in the car at the time of the accident?
Yes, it was.
Was it working properly?
Yes, it was.
So the car had been driven from December until July, until the accident, is that correct?
Yes, correct.
So the tires that were purchased in December would have been approximately 7 months old at the time of the accident?
Between 6 and 7, yeah.
And the car was driven regularly for the period that the new tires were on it?
Yes. Not a lot, but yes.
Well, how often was it driven?
Twice a day, usually.
Okay.
Or unless we had, had to go shopping or whatever. On average, it would have been about, I would say 60 miles a day or so, 65 miles, something like that.
Okay. I have no further questions.
Thank you. Anything further, Ms. Canfield?
No, Your Honor.
Thank you, Mr. Shibler. You may step down. Any further evidence from the state?
No further proofs, Your Honor.
Mr. Gibson, do you wish to produce any testimony or evidence?
That's not gonna- I don't believe so, yeah. I just a closing argument, that's all.
All right, fair enough. We'll let the state go first, and then you can make yours, Ms. Canfield.
Thank you. Your Honor, as I've stated, we already have the $402.27 for the items in the car stipulated to. Now, with respect to the lost wages of the victim, she indicated that she lost 5 days of work. Approximately 3 of those were covered. So we will be asking for.
She had 2 days off, so she missed 3 days of work, and what for her would be a Saturday and a Sunday.
So, Your Honor, she forfeited those days off by having been injured.
And she was compensated by the insurance company for the days lost. So if you were injured on a Wednesday, you missed Wednesday, Thursday, Friday, you had Saturday and Sunday off, you went back to work on Monday. That appears what the insurance company compensated them for.
Well, I still think that she needs 2 days because 5 of those were lost and they only covered and compensated for 3. She is an hourly employee. We're not even asking for the overtime if we're not going to consider the additional 2 hours that she worked of overtime per week. And that is direct income loss as a result of this accident. The court saw the vehicle. It's very fortunate for Ms. Shockley and her family that she was seat belted, and actually for the defendant, because this could have been much worse and she could have been.
Stop. As you may know, I have a sore point for under prosecuted vehicular accidents with an injury. That all goes to whether this should have been a felony rather than a misdemeanor. And so it is terrible. But we got a misdemeanor. We're trying to figure out the restitution. So the fact that it was bad is bad, but it isn't relevant to the restitution.
Well, Your Honor, I think it is in the fact that she indicated she had a sprained shoulder and subsequent head injuries.
I agree 100%. That's why this should have been an OUIL with a serious injury, but it
Your
isn't.
Honor, I don't mean to be disrespectful to the court. I'm just stating that these are important for the court to hear with respect to restitution, because additionally, her father, although he was allowed to work remotely, also had to provide daily living and assistance for her for those 2 days while she was in the initial injury phase. Now, with respect to that, they also had psychological injury. They're not claiming any compensation for that, although I can't imagine the call being received or a text from a daughter who'd been in an accident and not knowing her condition. With respect to the property damage and loss, it's clear here that I'm sorry.
Shibler.
Thank you.
I was just blanking on that last name. Mr. Schibler had testified that he had to replace the Model 2 with, again, the same year Prius, but a lesser, or the Model 4 with the Model 2. And he wasn't even requesting the blue book value of the vehicle they lost, only the difference from what the insurance paid to the vehicle that he had to replace. So if purchased at $6,500, only compensated for $3,900, $2,600 would be the difference. But then he had to do 27,1072 of his PTO because you also had to do the transfer plates, the insurance, the licensing, and the title for that vehicle that replaced the one that was lost due to the defendant's criminal conduct. So I would respectfully request that that entire 27,1072 be included as well. Now, when you have here a somewhat unusual argument with respect to the air conditioning and the tires, but at this point, Mr. Schibler has testified that the air conditioning had been broken over the winter. It was replaced approximately 6 weeks prior to this accident, and then the vehicle was totaled. The insurance company was provided that cost for the tires as well as for the air conditioning. He indicated they did not compensate him for same and being unable to utilize that vehicle that was just repaired. It's my belief that the air conditioning cost should also be paid by the defendant. Similarly with the tires, I try to do some quick calculations with respect to the mileage, but it appears that the mileage for those 6 to 7 months of utilization, according to Ms. Shockley and Mr. Schibler, would have been somewhere between 5,000 to 11,000 miles on those brand new tires. At the time the air conditioning was replaced, those tires were checked. They were still in new pristine condition with, say, a little wear and tear. So I believe that the tire amount should be compensated as well, because as Mr. Schibler testified, when he saw the vehicle subsequent to the accident and also met there with the insurance adjuster, the tires were damaged and shredded. They were not able to be saved. Those also were not compensated by the insurance company. And I certainly understand the questions of the defense as to, well, why didn't you challenge that with the insurance company? Why didn't you get an attorney to ask for a higher replacement value for the vehicle, considering the blue book values at the time? He simply said, I was caring for my daughter. I needed to work. He's also testified he's in a bankruptcy proceeding. He's got a lot going on where he just didn't have the time to argue, and they needed a vehicle toot sweet. So they replaced it with a much lesser model in a time that they needed to, so they can continue with their work and daily living. I don't think he should be faulted for the fact that the insurance company chose not to pay the blue book value. We wouldn't have been in this situation but for the criminal conduct of the defendant. So I'm respectfully requesting the items in the car, the 2 days of lost wages for the victim, the PTO loss that was cashed in to cover the balance of the vehicle not covered by insurance, as well as the air conditioning and the tires. And I do believe that those fall all under the income loss and property damage and destruction that are included under the statute under 780.766, as well as the case law previously stated on the record.
Well, the McAvoy case didn't seem to match up with that, at least the one I got. It had to do with whether parents were responsible for restitution for juveniles. So I didn't.
Well, there is also for income loss, Your Honor, People versus Turn, 317 Mishap, 475, as well as People versus Corbin, 312 Mishap, 352 at 371. And all of this, I should note, I've taken out of the bench book for restitution.
All right, thank you.
Thank you, Your Honor.
Mr. Gibson, what's your position?
For any lost wages type restitution, the statute talks about after-tax compensation, so, or after tax, so that should be factored in. So we would ask that roughly 80, that any amounts be made 85% due to the after-tax amount. As far as we have to look at the statutory law. So I understand that the victim, the father of the, well, I guess you could say the father, he paid money, he took time off to pay for a vehicle, but that, I guess when I look at the statutory structure, I guess all I see is replacement value as far as, you know, returning someone to where they were. If you can't repair the vehicle, then the statute talks about replacement value. So I guess where I'm a little bit confused would be, what would be the difference in the replacement value versus what did the insurance contract pay the victims in this case? I guess most people, I guess, would believe that the insurance company would pay, I guess, the value of the car or something that would be close to the replacement value. So I guess I'm not clear about that, but in a sense, they're not asking for replacement value, they're asking for paid time off of one of the victims, and I can't see anything in the statute that would.
It's kind of a convoluted way to get at it. Let's say that he cashed in his retirement account and used some money for that, or he used a CD that he had and he had to cash it in early and lost interest on it. It doesn't, to some extent, matter what the source of the funds were that were used, is how much was the cost. Let's say he borrowed it from the bank at 7.5% interest. He would incur an interest cost. So I'm trying to figure out the value rather than where the money came from. But
and maybe it's wrong for me to focus on where the money comes from, because I guess in a sense he's saying that this was part of the replacement value, but I guess that's where I'm confused, is that it seems like that the insurance company should have paid either the replacement value or something very close to the replacement value. So I guess I guess I'm still not quite clear about that. And I do believe that, you know, any restitution should be offset by any type of insurance benefits that were received by the victims. But as far as the replacement value, I guess the defendant would object to the way that the prosecution has asked for it in this case. So I guess we would object to the $2,710.72. And we would object to now as far as the $559.59 for tires and $424.84, again, we would object to those because I don't believe the statute would call for those. But also, even if we took the state's argument, there was approximately 7 months of tire use and a few months of air conditioner use. So it's not as if those were just brand new repairs that had just been done like the day before. So I would ask the court to take that all into consideration. Thank you.
Brief rebuttal, Your Honor.
yeah,
Statutorily, the replacement value can also be considered the fair market value of the property at the date of the damage, loss, or destruction. Arguably here, it is the cost of the vehicle as testified to by Mr. Schibler, which was $6,500. And again, his PTO covered the portion that the insurance didn't cover. We're not requesting the portion that the insurance covered, only what he had to cover additionally.
yes.
With respect to the after-tax compensation, I've calculated if 2 days are granted by the court, 85% of that would be $200.32.
Yeah, that's the figure I got.
But I still believe that the air conditioning and tires were in the condition relatively new. The air conditioning had been used probably less than 6 weeks and would have presumably been continued to be used for the duration of the ownership of the vehicle had it not been totaled by the defendant's conduct. So again, we would just ask the court order as requested the things mentioned in prior argument. Thank you.
Thank you. All right, as I indicated, this is a topic we discuss with new judges at new judge school. I spent a day with another judge from Farmington Hills teaching sentencing. These are tough questions without clear answers often. The quintessential case where the insurance company pays X and the car owner believes the car is worth much more than that. So the insurance company reimbursed them for this Prius with 200,000 miles on it for $3,900. And I'm sure it was probably worth more than that. But we don't have any real testimony about the fair market value of the vehicle. We have hearsay that Mr. Shibler looked it up on Kelley Blue Book, which isn't absolute gospel. And it was worth substantially more than that, which I don't have any trouble believing. What we do know is they had to buy another vehicle similar with less features. For $6,500. That didn't include taxes, closing costs, and it was a lesser included vehicle. So I'm going to get at this by, and presumably the insurance company has some expertise in valuing vehicles. And I think it's common knowledge they pay less than what the owner thinks the vehicle is worth. This is a no-fault state. If this was a civil case, everybody is presumed to be covered by their own insurance. The Shiblers and Ms. Shockley could have sued for the mini tort difference, but this isn't a civil lawsuit, it's a criminal case. So I'm going to allow the stuff that was in the car that the defendant stipulated to $402.27. Even though it probably was a weekend, she wasn't reimbursed for those 2 days, although $200 for lost wages. And what I'm going to do is I'm going to value the car, 2013 Prius. We do have some logic to replace it with. It was a lesser model and doesn't include the closing costs and the other fees that go with it. So I'm going to allow $7,500 for the new Prius minus $3,900 that they were reimbursed. Is $3,600. The business about the air conditioning and the tires is a red herring. The car is worth what it's worth. So how do you value that? I painted the car in September, so I should include the cost of a new paint job. Last June, I put new leather seats in it. So if we're chasing tires with 10,000 miles on it and a functional air conditioning unit, you would presume that it would be. That's what the car was valued, with functioning air conditioning and tires. The insurance company paid $3,900. So I don't have a lot of sympathy for you. This was bad, and Ms. Canfield spoke to that. You're lucky that you weren't killed. She wasn't killed. The guy in the other car that took off, they weren't killed. It was bad. And so it is what it is. So I'm allowing, find a note. total that up. $3,600 for the value of the vehicle that they had to pay to replace it with a comparable vehicle. $200 for lost wages, plus $403, we'll call it, is $4,203, which ironically is close to what they were asking for. So as a condition of your probation, I'm ordering that you pay $4,203 restitution to them for what it cost over and above what the insurance to replace the car, her 2 days of lost wages, and the items that were in the vehicle. So Ms. Walton, you can amend the probation to include $4,203 worth of restitution.
Thank you, Your Honor.
Thank you.
And of course, now the big thing will be collecting that, even if it is a condition of probation. That is not always the easiest thing to do. Honestly, it's never an easy thing to do. All right, my friends, I have to run. We will see you all tomorrow, 9 a.m. Eastern, 6 a.m. Pacific. Go have yourselves a great Wednesday. Take care. God bless.